T-U-R-N-E-R.
Ms. Turner, before you go any further, if you don't mind bending that microphone towards you, it was set up for a different purpose. There you go. Perfect. Although I'll tell you, you get an A+ on projecting. I think people could hear you anyway, but now the microphone, we're good with Zoom. I mean, with YouTube. Thank you.
Ms. Turner, you've already given us your name. Can you tell us how you know Mr. Yancey?
Mr. Yancey is my oldest uncle.
Okay. And where do you live in Atlanta?
I live in Riverdale, Georgia.
Okay. How long have you known Mr. Yancey?
All my life.
Okay. Can you tell us a little bit about your relationship with him?
My relationship with my uncle is every Saturday we go over to my grandmother's house. He stays across the street, and we always have family gatherings. So me and my uncle were pretty close. Whereas, talking, and he'll let me know things that's going on in his life, and we'll talk about things. He'll talk about things that's going on in my life as well.
You were shown a video by the police. Can you describe that video?
The video that I was shown, was photos from the video, and all that I saw was my uncle falling down on the ground.
And when you say your uncle, ma'am, and just because as I understand it, there's several Yanceys who are alleged to have been involved. You're referring specifically to Bobby Yancey.
Yes, Your Honor.
You saw still photographs that depicted your uncle falling to the ground.
Yes, Your Honor.
Okay.
And these police officers, did they describe the crime that was committed to you?
They did describe the crime. Yes.
Was it a shooting?
Yes.
Okay. In any of the pictures or stills or anything that you saw, was Mr. Yancey holding a gun?
No.
Was he shooting a gun?
No.
Okay. So the only thing it showed was Mr. Yancey falling down.
Yes.
Do you happen to know why he was falling down?
He was heavily intoxicated.
Okay. I just want to ask you, in your time knowing Mr. Yancey, has he been a violent person?
No.
Does he have a reputation as a violent person in the community?
No.
Okay. That's all I have, Ms. Turner. Mr. Abate may have a couple questions for you. I don't know if he does.
Okay, thank you.
Mr. Abate, any questions for Ms. Turner, niece of Bobby Yancey?
Just one. So was the purpose of the detective showing you the photographs was to identify your uncle in them?
He wanted to identify several people in the photo.
And were you able to identify your uncle Bobby Yancey?
I was able to identify, yes.
Okay. Were you able to identify anybody else in the photos?
Yes,
Who?
my uncle Gary.
Okay. And you would agree that you didn't see really any part of the video, correct?
I saw the video photos that the detective showed.
Okay. So you just saw still images, not the continuous or any of the actual video where the people or anything is moving or going on.
No actual video, but photo images as they were playing through the video. That's how he described it to me.
Okay. No further questions.
I just want to make sure, Ms. Turner, I understand. You met with a detective and it sounds like the purpose was, could you help me? Who's this person? Who's that person? That kind of thing.
When I first originally went with him, Your Honor, I came to ask questions about what was going on.
Sure.
At the home. They had a search warrant. So that's why I originally went for my grandmother's purposes. When I arrived, I asked him exactly what was going on. He told me to hold a second. And he pulled out, he said, these are the images from the videotape at the gas station.
Okay.
And so then he said.
And he showed you, was it on a phone or he had?
It was actual photo.
So he had pieces of paper.
The paper and the actual way that it was, because I actually thought that it was my other uncle that may have been the deceased victim.
You thought your uncle may have been the person who was killed?
Yes.
Was your
One of my uncles, yes.
And was your uncle the person who was killed?
No.
Okay. So you've got an uncle named Gary.
Yes.
And you saw him in one or more of the pictures.
Yes, clearly, yes.
And then you've got the uncle here, Bobby. You saw him in one or more of the pictures.
I saw him in one boat that was on the ground.
Okay. And you said he was drunk. Were you there when this happened, or how did you know he was drunk in the photo?
When I went to his house that day after they did the search warrant, my grandma had already called us previous,
Your grandmother
My
had.
grandmother, yes, my grandmother Margaret, she stays across the street from Bobby. And she had already called us previous telling us that he went to the store. So I know that he drinks. So when I went over to the house after the detective left to clean up, there were actually open beer containers that hadn't been finished that were drinking out of. So, and they were pretty large containers. So, and that was right when.
Okay, got it. Hold on one second. Got to mute. There we go. Thank you. Did you have any follow-up, Mr.
Just
Cullen,
to
based on that?
Follow up very briefly. So the pictures of Gary Yancey, what was he doing?
Gary Yancey was standing there. They had one of him standing there. They had another one of him moving towards the guy.
The guy being the person who was killed?
The person that was killed, yes. They actually, once I saw that photo, they identified him and I was able to, they showed the guy who, unfortunately deceased victim, and they showed the people that are around him, and Bobby was not around him, but my uncle Gary was, it was very descriptive, or I could identify him. So that was.
Okay.
Thank you, Ms. Turner. I have nothing further, Your Honor.
All right. Thank you, Ms. Turner. You're free to step down.
Your Honor, I'd like to call David Lowell at this time.
All right.
So raise your right hand, please. What you say now? You swear or affirm to the testimony you shall give to the court the truth, the whole truth, and nothing but the truth, said yeah.
Yes, sir.
Merci. State and spell your name for the court, please.
David Lowell, DAVID LOWELL.
Now, Mr. Lowell, thank you for coming today. Can you tell the court how you know Bobby Yancey?
Bobby is a employee of mine for the last 41 years.
Okay. And what do you do for work?
I'm in the live event concert production industry in Atlanta and throughout the United States.
Okay. And I understand that you've prepared a short statement that you'd like to read it to the court?
Yes.
Okay. With the court's indulgence, may the witness read a statement?
Sure. Just read slowly so the court reporter can keep up with you.
Okay, I'll try to make it short and sweet, so thank you. My name is David Lowell, and I come before you today as a character witness for Bobby Yancey. For the past 41 years, I've worked in the live concert industry, and Bobby has worked with me for my entire career. Prior to Bobby working with my company, he worked for the late Senator Haskew Brantley, who was the state senator for the 56th district of Georgia. Senator Brantley loved Bobby and asked me to employ him when his career ended with the Senate. Bobby is well loved by all the people in the entertainment industry. He is affectionately known as the hardest working man in show business. Besides being a loyal employee, Bobby has been there for me and my family in our times of crisis. When my son was a young teen, he went missing from a juvenile treatment center in the North Georgia mountains. Bobby was the first man I called when I needed to get a search crew together. After hiring a helicopter and spending hours searching for my son, we finally spotted him standing on a bridge threatening to jump. As we were all cowering and scratching our heads trying to figure out the best way to approach my son, I looked up to see Bobby running across Highway 441, dodging cars, and he literally tackled my son. It was like out of a Mel Gibson movie. I am forever thankful for Bobby's heroic efforts to save my son's life. When COVID hit, I helped Bobby guide him through these tough times. And as of today, all of Bobby's bills have been paid through the end of October, but his lease ends October 31st. And I am afraid if he can't get back to work, his entire house of cards is going to fall. He's going to lose his house, his car, and I don't know where his items will end up. I also ask you to take Bobby's 79-year-old mother into consideration. At this point in her life, Margaret Yancey has all three of her adult male children in jail for the same murder at the same time, not to mention an 83-year-old husband in early stages of dementia. I can't imagine what she must be going through. As I said earlier, I've worked with Bobby for 41 years. He is not a murderer or a threat to this community. Knowing Bobby, I'm certain that this is just a classic case of Bobby being in the wrong place at the wrong time. And I respectfully request that you grant Bobby bail so that he can get back to work, his life, and his family. Thank you.
Thank you.
So, Mr. Lowell, it's safe to say that Bobby has had a tremendous impact on your life.
Yes.
Has he ever displayed anything that would make you think he is violent?
No, he has never done that.
Thank you, Mr. Lowell. That's all.
Mr. Abate, any questions for Mr. Lowell?
No, Your Honor.
Thank you, Mr. Lowell.
Thank you.
So, Your Honor, the court has heard the testimony in favor of granting Mr. Yancey bond. So the question now is, how do the bond factors apply to Mr. Yancey? So first, does he pose a significant risk of fleeing from the jurisdiction or failing to appear in court when required? No, he lives in Georgia. This is his home. He's lived in Georgia since 1980. If granted bond, he will go right back to living at 1609 Ebony Terrace, Atlanta, Georgia, 30318, squarely in the jurisdiction of this court. It's the only place he has to go. He's a 63-year-old man who's been in Georgia for more than 40 years. He's not going anywhere. Bobby has never had an FTA. Nothing in his history suggests he would fail to appear in court. So does he pose a significant threat or danger to any person, to the community, or to any property in the community? We've heard what kind of person Bobby Yancey is. We've heard the kind of effect he's had on his community and on individuals like Mr. Lowell. We've heard the effect that he's had on people's lives. Bobby is a father to 2 daughters, a brother, and an uncle to Ashley Turner, who's here speaking for him today. He's not a danger to the community. He's a beloved member of it. And that's why these people you're hearing from are here today asking for his release. So does he pose a significant risk of committing any felony pending trial? Again, why at 63 years old, in declining health, would he start committing felonies? Now, I understand that he may have something back in like 2000, maybe something in 1987. But why at this point in his life would he start committing felonies? There's no reason to suspect he would. Further, the crime that he's accused of committing is not a crime that suggests further criminality. This is not a crime like drug trafficking or mugging someone to get a fix, where you're an addict and you can't get out. You just have to keep committing crimes. Your life is basically one long series of felonies. No, this arises out of the fact that Bobby Yancey was in absolutely the wrong place at absolutely the wrong time. And there's video evidence to show that. I don't think the government has had a chance to realize this guy isn't a criminal. He's actually going to be one of our witnesses to the crime that was committed. So does he pose a significant risk of intimidating witnesses or otherwise obstructing the administration of justice? Again, no, he is a witness to a crime. He doesn't want to obstruct the administration of justice. I believe he wants to help it. If we keep him in jail, why are we keeping him there? Why are we breaking with the norm that in all but the most extreme cases, cases where we simply cannot let someone out before trial, we want people to remain free to mount their legal defense? Does Bobby Yancey justify such extraordinary measures? No, he does not. Now, Mr. Yancey has had a lot of questions about what's going to happen here today. He's worried that the charge itself is what determines whether or not he gets bond. But I've told Mr. Yancey what this court is actually going to do. It's going to look at his charge. It's going to look at his history. It's going to consider the words of his friends and his family. It's going to look at the Ayala factors. And I believe it's going to conclude that Mr. Yancey is not such a threat to society that he must be kept behind bars to prevent further damage to the community. That, because he is not a risk, is why we are asking for $55,000.
Hold on one second.
What did I hear?
All right, you're unmuted now. Hopefully everyone else stays muted. You're up.
All right. We're asking for that because he was at most a bystander in this case. If this court is concerned about monitoring Mr. Yancey's whereabouts, we have no objection to an ankle monitor and a curfew. Now, I believe Mr. Abate is going to tell the court that this is a crime involving 3 brothers, and it may sound like these 3 brothers are all equally involved. That is not the case based on everything we know about this. Mr. Yancey, from everything we know, was highly intoxicated and was simply there. Now, that may be a problem, but it certainly does not make him a danger to the community. Thank you, Your Honor.
Couple questions. How does Mr. Yancey get around? If he was gonna be on bond and get to work, but maybe he'd need to be reporting pretty regularly to pretrial supervision, how does he get from point A to point B?
It's my understanding that Mr. Yancey does have a vehicle and does have people to drive him if he's not able to drive that vehicle.
Do you have a valid driver's license, Mr. Yancey? You gotta say it out loud.
Yes,
And you've got a car?
yes,
I guess that's right. Mr. Lowell said he was worried Mr. Yancey might lose his car. And is Mr. Yancey working? I heard what Mr. Lowell said, but what?
It's my
What's your
understanding that
understanding?
he's still employed by Mr. Lowell
Okay,
at this moment.
got it. Those are my questions for now. You'll get the last word as the movement, but let me hear from Mr. Abate,
Thank you, Your Honor.
please.
Judge, do I remain here or should I come up to the podium?
I think if you use that microphone, it'll work. If not, I'll hear from Ms. Rivers and you'll come up to the podium.
Yes, Judge. Judge, I would respectfully request that you deny defense counsel's motion for bond for the following reasons. I know defense counsel indicated that the defendant, Mr. Yancey, did not have any failure to appears. He does have an FTA out of Fulton State Court back from 2003. It was October 19th, 2003. So it's been a number of years, but I wanted to bring that to the court's attention. I would also submit to the court that the defendant was a threat or is a threat or danger to the people in the community in it based on the facts and circumstances of this case. I spoke at length with Detective Demeester yesterday, who described all parts of the video to me as he had watched them many times. And what I was able to understand was that the defendant, Mr. Yancey, or Bobby Yancey, is seen driving his vehicle with his 2 brothers, Gary and Gregory, in the vehicle. They are driving around Perry Boulevard and Hollywood Road in that area of Atlanta, and they go to a gas station where they circle the parking lot. And based on Detective Demeester's investigation, they're circling the parking lot because this is where the victim, Mr. Frederick Mason, is commonly at or seen or in that area. And they are looking for him because days before there was an altercation between Gary Yancey and the victim, Mr. Mason, over a female. They don't find him in the parking lot, so they are at the gas station, so they leave. And 20 to 30 minutes later, they come back to the gas station to continue to look for Mr. Mason. They see Mr. Mason across the street at the Hollywood Boulevard or Hollywood Street MARTA station, where you can see Mr. Bobby Yancey drive the vehicle from the parking lot, literally stop the car in the middle of Hollywood Road, and all 3 of the defendants get out of the vehicle barely before it stops, is the way Detective Demeester describes it. And all 3 of them begin to punch, kick the victim, Mr. Mason, in the middle of the road. At that point, Gary Yancey is holding Mr. Mason down, and Mr. Bobby Yancey and Mr. Gregory Yancey are both punching and kicking the victim as he lay on the ground. The victim is able to get up and starts to run away from the 3. At that point, the 3 defendants go back to Mr. Bobby Yancey's vehicle, and Mr. Gary Yancey gets into the back seat, and Bobby and Gregory do not. What happens is Gregory pulls what both Gregory and Bobby said was his revolver, as in Mr. Bobby Yancey's revolver, out of the vehicle, take that revolver back towards the victim, Mr. Mason. And when I say took the revolver over there, it was Mr. Bobby Yancey and Mr. Gregory Yancey walked towards the victim. At that point, Gregory Yancey does, from what Detective Demeester can see on the video, pistol whip the victim and then shoots the victim. And at that point, Bobby Yancey and Gregory Yancey go back to the vehicle, and Bobby drives the vehicle away from the scene with both of his brothers and co-defendants from the scene. All of this is seen on video pretty quickly. Detective Demeester goes by Bobby Yancey's house around 2 a.m. His vehicle is not there. He goes back around 4 a.m. His vehicle is there. Between the time that the incident occurred and 4 a.m., the gun disappears. So that would be the reason the state would submit to the court that the defendant is a threat or danger to the people in the community in it. I'd also bring to the court's attention, because defense counsel and his witnesses, Ms. Turner, has made clear that Mr. Yancey was drinking that night heavily. He's seen on video driving all over the city of Atlanta, further putting the citizens at risk and danger, Your Honor. As to the risk of committing felonies pending trial, I would agree with defense counsel. The only felony conviction that Mr. Yancey has is back from July 15th of 1985. It was an aggravated assault where he just received 5 years probation, Your Honor. And I would agree with defense counsel. There's no real risk of any intimidating of witnesses, as the incident is, a lot of it is caught on video.
Is it on video because you've got a gas station and a MARTA station, or was there a concerned citizen saying there's this car in the middle of the street and these three guys have jumped this guy?
The gas station and the MARTA station, Your Honor.
Okay.
And as the court knows, his brothers are his co-defendants, and it's my understanding, and I could be wrong, that they all live in the same home or very close to each other, which is a concern for the state. So at this time, Your Honor, the state would respectfully request that you deny defense counsel's motion for bond, and he remain in the custody of the Fulton County Sheriff's Department. And Your Honor, the son of Mr. Frederick Mason, who is Andrew Mason, wrote a victim impact statement. Whenever appropriate, Miss Lona Rolock would like to read it into the record.
Sure. Now is if you're done
Yes.
with your presentation, then I'd like to hear from Ms. Rolock on behalf of the Mason family. And then I have a couple questions for Mr. Cullen, and he may have something he wants to share. Good morning, Ms. Rolock.
Good morning, Judge. This is from Andrew Mason, Mayson. Good morning, Judge. I am the son of Frederick Mason. Sorry I can't be here for the bond hearing. I just want to say this guy should not be granted a bond. As far as I know, he took the life of my father intentionally. He knew what he was doing, period. He made that bed and he should lie in it. It wouldn't be right for this guy to be on the streets living his life when, as far as I know, he took a life, and it was on purpose. I miss my dad. I will never see him again. All over nothing. That high may have come down on this guy. Now he want to get out of jail. No way. Please deny his bond. Thanks, sincerely, Andrew Mason. Thank you, Judge.
Thank you, Ms. Rolock. And Mr. Mason, if you're plugging in via YouTube, thank you for sharing that. And we're all sorry for your family's loss. Mr. Abate, I just want to make sure I understand in the end, you believe in your communications with Detective Demeester that what the video evidence would show, and then presumably witness testimony, is that Gregory Yancey used what's been described as Bobby Yancey's revolver to pistol whip and ultimately shoot and kill Mr. Mason.
That's correct, Your Honor.
Okay. Thank you.
Thank you, Judge.
So, Mr. Cullen, I'm happy to hear your responses, but I have a couple questions as well. You can weave your answers in. One is, you may have said it, but I missed it because I was jotting down other things, what you think a reasonable bond amount is. Another is, what is your client's living situation? You gave the address. Who else lives there, would live there? And have you seen the video?
Well, I'll start with the last one, Your Honor. I have not seen the video. We've requested it. We haven't seen it. It seems that, people have seen stills from it. And I do want to address that video a little bit, just regarding Mr. Abate's questions. I find it hard to believe that if we had this whole video with Mr. Yancey walking, standing, beating someone up, all these different things, that the best they could do for an identification is a still where he's fallen down and it's hard to see him. I think we have a genuine confusion of Yanceys here. It is Gregory Yancey and the other Yancey brother that seem to be involved in this. Additionally, I've been told by people who have seen stills of the video that Mr. Yancey is seen as a passenger in this car.
You're Bobby Yancey.
Bobby Yancey.
Okay.
Yes, is a passenger in this car because he's drunk. He can't drive. So
What do you have to say about whether it was his car in which the brothers Yancey were traveling?
it is his car. It's his car. I believe the gun may be registered to him. However, I don't believe he's facilitating any of this activity. I think he's literally falling down drunk. As far as his residence, I do believe that at least one of the other brothers who is currently incarcerated was living there with Mr. Yancey. Now, if that's a problem for the court, I'm sure that Mr. Yancey can arrange for alternative residence. The bond I requested when we were having a little bit of trouble with the YouTube was a $25,000.
Okay, that may have been when we broke down.
Yeah.
Okay. All right, anything else?
No, Your Honor.
Thank you. Mr. Abate, how complicated would it be, maybe because it's multiple videos or whatnot, to get video footage so I could review it and obviously Mr. Cullen could review it? I don't mean right now. I don't need to decide right now. I may want to see some of the video that shows a threesome pursuing Mr. Mason as opposed to a twosome, that kind of thing. I just don't know how fragmented it is and what your understanding of that is. And do you know, look, they've actually compiled it and there's one thumb drive that has it all on there, or it's 18 different systems, and it would literally take hours because you'd need to be looking at this clip from this angle and that clip.
I don't think it would take hours, Your Honor. I think I could get the relevant portions, or at least all of it, and then be able to identify based on Detective DeMeester's investigation, the relevant portions of the video for Your Honor and defense counsel to watch. I would walk down to APD and put a jump drive in his computer and get it. Shouldn't be hard.
Okay.
Your Honor, I apologize for interrupting. I need to correct myself. Mr. Yancey stays alone. I was under the impression that one of the brothers lives with him. That's incorrect. He has his own house.
No, I saw his niece react, so I understood he lives alone.
Yeah. Well,
which-
and that is the address that I gave.
Yep. Okay, so he happens to live across the street from his mother. The other brothers may visit, but that's not their home.
That's correct, Your Honor.
Okay. That wasn't going to be an issue. I mean, a condition of bond would be you cannot live with your brothers. And so they'd need to find their own place if they get a bond. That's not before me today. I just have Bobby Yancey. All right. So I would like an opportunity to look at some of the video footage. I'm sure you would too, Mr. Cullen.
Yes, Your Honor.
And so what I'm going to ask Mr. Abate to do is to get an email to you and Ms. Nelson saying, I think I can get that in the next day or two. If the answer is because of technical reasons or DeMeester's on leave, I can't get it for 2 weeks, I won't wait for it and I'll come up with an answer. But I might be willing to revisit that answer after we get a chance to look at the video. And I'll tell you, Bobby Yancey, and I'm using your first name so the record's clear. There are sort of these competing narratives. They're not in conflict in that pictures show what pictures show. So if it's clear and what I see is you conked out on the ground and two other people, presumably your brothers, but it doesn't matter, they're not you, going after Mr. Mason, that's a very, very different situation than three people emerging from what we understand is your car, those three people assaulting Mr. Mason. Ultimately, I'm hearing it's Gregory Yancey who performed the final act. But if you were in that scrum, that's a very different situation than if you literally rolled out the passenger side of your car and were lying on the ground because you couldn't stand up. And I would handle those differently in terms of bond, no bond, what that bond would look like. It may be from the video, I can't tell. And then I'll need to work with what everyone's talked about here. But I just don't want you to be surprised. I'll be much more inclined, and I believe I can set a bond that has conditions that would include an ankle monitor, stayaways from your brothers, et cetera. If the video evidence is pretty clear that you weren't in the mix at all. If the video evidence is pretty clear that you were in the mix, you may be 62, but you got in the mix, and you're probably going to stay where you are until your lawyer can get more discovery, and we may revisit that topic. If, which is probably the most likely, you just can't tell from the video, then I'll need to work through what I've heard from both sides, what I'm going to do, and we'll go from there. Mr. Cullen, do you have anything else you want to share or questions based on what I've just related?
No, Your Honor. Would we be getting an email within the next 24, 48 hours? Is that?
Yeah, so Mr. Abate, unfortunately for him, has 5 more bond hearings with me this morning. And as he's experienced in the past, there may be other due outs from those other ones. But what I'll know he'll do, and he may rely on staff support, someone will reach out pretty quickly to the detective to say, how soon could we get this? And how complex would it be for you to help us navigate? Watch this clip, and this clip. And we ought to know whether that's doable in the next 24 to 48 hours. Because like I said, the answer may be, oh, the system is down for 3 weeks. Then I'm not going to wait on that. I'll do what I do. But as always, I'm happy to revisit if you eventually get the video footage and you're able to see, look, there's Bobby Yancey, and he opened the passenger door, rolled out, and lay there the whole time. That is a very different situation from the version that Mr. Abate believes the video will show based on what the detective told him. But I appreciate he is having this translated for him by the detective, much like you were relying on people talking about little snippets of the video. And I just like to get it as accurate as we can, and we'll go from there. So soon I want to get an answer to you and your client as to what the situation looks like. Mr. Yancey, your bond stays with me until you get indicted. So if I initially don't set a bond, or it's a bond you can't make, Mr. Cullen is free to petition to have me reconsider that as time passes, and maybe your lawyer gets more information about the facts and circumstances of the death of Mr. Mason. And I'm happy to revisit it. Once your case gets indicted, it'll be assigned to a judge randomly. It could be me, only a 1 in 15 chance. That's where discussions of bond will go after it gets indicted.
And Judge, I just reached out to Detective Meester, and he said he can share the video through evidence.com at some point today. So as soon as I get it, I will forward the link to both counsel and Your Honor.
Just like that. Thank you, Mr. Abate.
No problem.
So, Mr. Cullen, I want to make sure you heard that last part. It sounds like we'll be getting a link to the video later today.
Okay, thank you, Your Honor.
Do you have any questions based on your conversation with Mr. Yancey, or are you good to
I
go?
did not. I was just explaining to him what you were saying.
Okay, great. Thanks so much.
Thank you, Your Honor. That concludes my business, Your Honor. May I be excused?
Yes, sir. Thank you for being here. And thank you, Ms. Turner and Mr. Lowell, for coming down. And Mr. Mason, if you're out there, for watching. So, Ms. Bray,
Yes,
how you doing?
I am doing fine, Your Honor.
Next up, if we go in the order of the calendars, Mr. Arnold, I'm happy to bring him out to tell him we'll see him soon, or it may be you want to do it today. Tell me your preference.
Says that he would rather do it today.
Okay,
So I'm ready.
excellent. We'll see what happens. I am as ready as you are. You're probably a little more ready because he's told you something about the case. I'm gonna look it up now. So it looks like the other 2 Yanceys are also in custody. All right, 21. So we're ready for Reginald Arnold when your team is, Deputy.
This is who? Whoops. Now, what in the world is this? Oh, Jesus. We ready?
Yes, Your Honor.
All right, let me get the record teed up. This is position 2, State versus Reginald Arnold. It's 21 CP 202539. Good morning, Mr. Arnold. Mr. Arnold, your lawyer will do the talking for you, Ms. Bray. She's going to tell me a little bit about your situation. I'm going to hear from the prosecutor, who's the gentleman walking towards us now, about your situation, and then I'll let you know what I'm going to do about bond. And that's all we're talking about today is just bond. That's it, okay? Great. Ms. Bray, when you are ready.
Yes, Your Honor. Your Honor, you have before you Mr. Reginald Arnold, who is 28 years old. He is a lifelong resident of the Metro Atlanta area. All of his family resides here in Atlanta: mom, dad, siblings, aunts, uncles, cousins, grandparents, everyone, Your Honor. He attended school here at Jonesboro High School. He did complete the 11th grade. He presents with an address that's different from what's on the pretrial slip. The address where he resides, Your Honor, is 6652 Bent Creek Drive, which is in Rex, Georgia. He's lived at that address for the last 2.5 years with his girlfriend, Katira Bussey, Bussey.
So any reason why all the booking information lists an apartment on North Main Street in Jonesboro? What is
A
that?
prior address with relatives, right? Where you can still go back to if you need to. Yes.
Okay.
Okay. All right. Your Honor, at one point, he was employed with the Clorox warehouse where he was for like 6 months. He also did work in landscaping and home maintenance. As Your Honor can see from my client's current situation, this alleged incident, this incident happened back in April of 2021 in Union City. Mr. Arnold was shot in August of this year. Don't know who shot him or anything like that, but the bullet went through the back of his shoulder and it's lodged at the top of his spine. So this took place in Clayton County.
Your client being shot?
Yes,
Okay.
took place in Clayton County. The incident, like I said, happened back in April here in Fulton County. Mr. Arnold was not aware of any warrants being out for his arrest or anything of that nature. Once he was being released from the hospital in Clayton, they transferred him to the Fulton County Jail. So that is when he became aware that, wait, y'all have warrants for me. So needless to say, he has not been able to work or anything since he was shot in August, and he has since been in the jail.
Do you know if there is an open case in Clayton where someone has been charged with shooting Mr. Arnold?
He is not aware of anyone being arrested yet for shooting him. We're not aware, Your Honor. But now, due to his being shot in August of this year and being confined to the wheelchair, he will need future medical procedures done to try and deal with the bullet that's still in him, Your Honor.
And I
Um,
noticed the way Mr. Arnold, so the record should be clear, Mr. Arnold's in a wheelchair.
Yes.
He's got what looks like a neck brace of some sort. His left leg is supported in a certain way. Is that just part of the overall injury, or was he shot in the leg as well?
No, my understanding of that is he was shot in the back of the shoulder.
One shot.
Yes.
Okay. And the bullet remains.
Somewhere lodged near the top of the spine, Your Honor.
Got it. Okay.
So he doesn't have full mobility with one of the arms here. Yes, it would be the left arm.
All right. And Mr. Arnold is following what we're talking about, but his responses to my couple questions at the beginning, and that'll be it for questions from me for him, were either he raised his hand to indicate yes, or he slightly nodded his head. But that's been the extent of his ability right now to communicate
Yes.
with me while we've been in court.
Yes, Your Honor.
Okay.
Okay.
Is there a timeline that you're aware of, either from talking with Mr. Arnold or getting information as to when he might be going back for procedures?
I'm thinking you've been to Grady since you've been. All right. You know, I know that they're keeping him on the medical floor to watch him. It would be hard for him to defend himself if they were to move him into Gen Pop or, you know, anything like that.
Yep.
I believe there's already been a situation where someone just ran into the cell and shoved him, and he really couldn't do anything except fall to the floor. So I know he needs to have future medical procedures done. He would like to have a bond so that he can pursue that safely on the outside of the Fulton County Jail. So I've gone over ties to the community. I do believe that now, well, definitely now in the situation he's in, that there's no likelihood that he would be able to intimidate witnesses or anything of that nature. He cannot physically do anything to anyone at this point, Your Honor. Not that I would say that he would if he wasn't in this condition, but I'm just saying he definitely physically cannot intimidate anyone or hurt anyone. Also, the initial report that I have, which is somewhat 3-4 pages long, mentions people that Mr. Arnold does not know. Mr. Arnold isn't mentioned in the police report at all. So he does not know these people that are listed as state witnesses. Third, I know that Your Honor will hear from the DA when it comes to likelihood to reoffend, that Mr. Arnold has an open misdemeanor battery case from July of 2020. That's out of Clayton County. And December of 2020, there are, I think, possible obstruction warrant or driving offenses from December of 2020, also out of Clayton County. I do believe that Mr. Arnold is not a flight risk. Your Honor may hear that he's had a prior FTA, but that prior FTA, he was in custody at the time in a different county.
Yeah,
when
he
he
has
received
an
that.
open burglary with Judge Barwick from 2015, a 15 SC, you don't
Yes.
need the whole thing, but he
Now,
clearly
he's been in custody
off and on in all those years, or?
from, let me see, I wrote it down, hold on. I know in 2016, according to the GCIC that I have, there was a burglary in the first, and what's listed as 4 years to serve.
Okay,
So that would explain that at some point, he's been in custody, yes.
sure, okay, but he now has, the case with Judge Barwick has been reactivated now that Mr. Arnold's back in custody, so I don't know if they're is a warrant from that as well. There was a judicial hold that was
Right,
lifted
so that would be.
because he's back. So we can look into that, but I just wanted you to know, because you were mentioning open cases. As old, it's a burglary, that's not gonna weigh real heavy.
I'm sorry, Judge McBurney. Judge McBurney. Judge McBurney,
Can you hear?
Oh, yeah, so what happened was that the call ended for the Zoom room and they all dropped off. So the podium is on. I'll add Mr. Abate and witness and defense while we're going, but we can get, I'm sorry to keep you standing up there, ma'am. I just needed to make sure that your microphone there worked. So Ms. Allison, I'm happy to hear directly from you if you think that would be difficult. Ms. Rolak can also share with me what it is you want to share. But why don't we start with you? And if you need to take a break, you just let me know, okay?
Yes, yes, Your Honor. My name is Charity Allison, CHARITY, Allison, ALLISON. I am the mother of the deceased, Robert Allison. I take my mess down.
Please.
Excuse me. I just want to say, first of all, I miss my son dearly. He was my oldest son, second oldest, my oldest boy. He was a brother, a father, a friend to many. He was goofy, but always a family priority person. I miss the talks with him coming over and just looking at TV and, you know, what children do, working my nerves, you know, but we no longer have that. All I have now is my memories, me listening to his music and pictures. I just wanted to say my son is gone. But most of all, it hurt because he have 3 precious little girls that has to grow up without their father. He wasn't a dad, he wasn't a part-time dad. He was fully, completely in their lives. And it hurts, Your Honor, it's hard to go on. You know, 26, that's young, you know, and I you know, hate this really happened to him, but I have to get up here and address the court to ask, to beg, to plead, to deny bond. I need justice for my son. I don't want to say the wrong thing. It was things that was mentioned that the prosecutor said or whatever, but at the end of the day, we all know what's going on, what was going on. So does Mr. Arnold. I just want justice for my son. I will ask the court to deny his bond. Thank you.
Thank you. How old are your granddaughters?
9, 6, and 4.
Okay. And are they all with the same mom? Are they with different
No.
moms?
No, one of the moms are here, my oldest granddaughter, but no, they all have different moms.
Let me just mute that phone. You're still able to spend time with them?
Yes, sir.
Good. Okay. Well, hold them, and I'm very sorry for your loss, and I appreciate you sharing that.
Yes.
Be safe.
Thank you.
Mr. Abate, anything else?
No, Your Honor.
All right. Ms. Bray, when they vacate the podium, if you would come back up for anything you want to add in conclusion.
Yes, Your Honor. Because as Your Honor was pointing out earlier, which were the basic things that the state has, but I want to point out what they don't have, Your Honor. The state or detective has spoken to the woman that Mr. Arnold was with. The state or the detective have spoken to the people that are listed in the initial report who were present. No one, not a single person, saw or even claimed to see that Mr. Arnold shot Mr. Allison. It's not on video. No one is saying that Mr. Arnold had a gun that night. No one is saying that Mr. Arnold and Mr. Allison got into an argument or a fight. No, Your Honor has heard Mr. Allison got into it with the girlfriend that lived at that apartment complex. And the argument was such that he left. Then he comes back. There's no reason given for why Mr. Arnold would shoot this man. It makes more sense to me that the state needs to look at that girlfriend that he got into the argument with. And it got so heated or whatever that he left. But I don't think the state has pointed out that he left after kicking in that door of that apartment. And it had something to do with her throwing his keys out and what have you. There's just no reason given why Mr. Arnold would do this. So it doesn't make sense to me. And if you have all of these witnesses, all of these people who have been spoken to, and no one saw him with a gun, no one saw the shooting. So I just don't think it's enough. All they have is, I guess a text message or a call saying, hey man, come back. You could have been saying, hey man, come back and work this out with her. This is your girl, work it out. And so I just don't think the state really has enough, based on what Your Honor has heard, to even charge him with this. And I am asking Your Honor to set a bond. Thank you.
You're welcome. Mr. Abate, one last question. If you know, you described some video footage that shows a black Mercedes leaving, piloted by a female. Mr. Arnold's a passenger. That female, Mr. Allison's girlfriend?
No, it's a
different female.
It is the female that Mr. Arnold came to Mr. Allison's girlfriend's home with, who was spoken to, as Ms. Bray did indicate, by the detectives, who said that Mr. Arnold and her left earlier in the day, but they don't leave until
After the shooting.
right.
Okay. All right. So Mr. Arnold's situation is complicated by his medical situation. There are a lot of things to balance here. It is complicated for the sheriff to maintain Mr. Arnold at the jail. They'll do that if that is what they're asked to do. It's hard to see Mr. Arnold at this point being a particular threat to others. Whatever he may have done to Mr. Allison, obviously that's as bad as things can get if that's what he did in this case. Someone shot Mr. Allison, and if it was Mr. Arnold, you can't get worse than that. I'm a little confused by the report of Mr. Arnold being an aggressor at the jail with this object in his hands. And so what I'd like to do, more homework for Mr. Abate, is get whatever report there was that was developed on that. And you need to get that to Ms. Bray as well. But I'd like to understand more about that situation, because my going in thought was that house arrest for Mr. Arnold keeps him away from Mr. Allison's family and everyone else. He's in Rex, Georgia, far from Union City. He could leave for medical care and come into court, and that would be it. And that will keep him out of harm's way and other people out of his way. But I'm concerned about whatever that incident was. I appreciate that it could have been actually the end result of someone shoving him to the ground and he's now defending himself. So I'm not concluding what that was about, but I'd like to understand more about it, because it undercut perhaps the mistaken notion I had that was developed by seeing Mr. Arnold here in court, that he's basically going to spend his time between now and whatever happens with his charges or his surgery sitting still. And there are reasons why that makes more sense for him to be in Rex than in Rice Street if he's just sitting there. For a lot of reasons. It doesn't address Ms. Allison's concern, and I heard her loud and clear, and I'm not minimizing that in any way. I'm trying to strike the right balance. So my request, Mr. Abate, is either you connect me with the right person at the jail who can get more info, or you get it, share it with Ms. Bray, and I will take it from there.
Yes, Judge.
And Ms. Bray, you can, Mr. Arnold can hear me, but if in the end, as a result of everything I've heard, I either decline to set bond or the bond is beyond Mr. Arnold's reach, we can always revisit this if this is a case that is not indicted in a timely fashion. It'll stay with me until it is indicted.
Are we back to the 90 days now, or?
Oh, yes.
We
You
are-
didn't hear about, I need $5 million because the judges are going to release all these alleged murderers? I heard that.
I heard it, Your Honor, but I thought Judge Lasher had reinstated it or something, so I was just.
He is
confused.
reinstating the speedy trial tolling. So you could file a demand for a speedy trial once your client's indicted, and that would be noted, but the 2 terms of court wouldn't start to run.
Okay,
That's the only thing that the chief judges around the state are able to.
that was what I didn't understand. All
Yeah.
right. Okay.
Okay. Thank you, deputies.
Okay.
Ms. Bray, Ramil Smith is next. Is that one you'd like to defer? You like? Okay. Sure, we could do Mr. Cho if he's ready. I'm not ignoring you, Mr. Francis. I'm just going in order of the calendar.
You said Smith.
No, what we'll do next is Gray, please. And Mr. Francis and team, before we bring your client out, we're gonna need to have a little bit of a discussion about whether he should come out. Folks have raised understandable concerns. If we got an email yesterday saying he shouldn't be moving, then maybe he stays back there because you've already waived his presence. But that could be explained to him, but. So Ms. Bray is going to talk to Mr. Smith. I don't know how long she'll be doing that. So then it's Gray is coming out right now. Right after Gray is Alan Jones.
That's how I.
It's good news.
And Ms. Patel, you are here for Ramel Williams.
Yes.
Great. We also have, if you don't mind picking up from Ms. Nelson, Ms. Wood had a under seal filing. All right, you should be able to hear what's going on again if you are connected remotely. Been having a few technical issues today. Ms. Rivers, you ready? All right, this is position 4, State versus Quintavious Gray, 21 CP 202594. Good morning, Mr. Gray. I'm doing okay. Mr. Gray, you are charged with murder. Looks like 2 counts. I'm going to have to look at your file in just a minute. Mr. Cho is going to talk to me this morning about bond and why you should get one and what it should look like. Mr. Abate, who is seated across from you, will be giving me the state's perspective on whether you should get a bond or not, and I'll let you know what we're going to do. Mr. Cho, when you are ready.
Thank you, Your Honor. Good morning.
Good morning.
Judge, if the court does look at the warrants in this case, and the court already noted, there are 2 counts of the most serious charge on the calendar. If you also go on the AJC website, they will also mention 2 charges in this case of the most serious kind.
I won't go to the AJC for purpose of this hearing. I will look in the docket.
Thank you, Judge.
Sure.
I think that's very wise because how it's been characterized in the media is inaccurate. It's maybe not the best word, but it's not the full picture. Judge, and I think that Mr. Abadi will also follow up on this, but in this case, there were 3 people who passed away. And one of the deceased, one of the victims in this case is my client's best friend. And so, Judge, what we are saying to the court in this case is that I'm very personally glad that there is no further judicial emergency extended as far as the 90-day rule and speedy trials and things of that nature. This is a situation where Justin Santos, listed as Jason Santos in the police report, also passed away. Judge, I think what's missing in this case to some extent is.
So I'm confused.
Yes.
But maybe you're gonna get to it. I have one victim, Denise Dupree,
That's
and
correct.
the other Corey McDonald.
Correct.
And hold on a minute, we got an iPhone that is, nope, it's Prince. Prince is now muted. Okay. So we've got Ms. Dupree and a Corey McDonald, but you
correct.
just mentioned a 3rd deceased.
Yes.
Okay.
Judge, if the court is able to access the police report and the warrant, those are the 2 deceased listed as the victims. There is a 3rd deceased in this incident.
Okay, and that's your client's friend.
Yes, and actually, just to be accurate, all 3 individuals were my client's friends.
Okay,
I think that there being a 3rd deceased in this incident during this incident date, during this time period is very relevant to this case. And notwithstanding the fact that we have not had a probable cause hearing on this case and have limited discovery at this point, Judge, I do think that the sequence of who died first is going to be very relevant in this case. I think the sequence of, well, I think the court is very wise. So I do think the sequence is going to be incredibly relevant to this case. And Judge,
Okay.
I will also say that toxicology, I think, results for the deceased will be very relevant in this case as well. Obviously, it's an early portion of the case, and so I'm not expecting that at the moment, but my point is this: there are 3 deceased in this case, 2 listed in the warrants for my client, but a 3rd there. And so that, I think, is very, very relevant. Judge, saying all that, we are asking the court to consider a reasonable bond in this case. I will say that I do not believe that Mr. Gray would be a risk of flight or missing court. I say that because Mr. Gray has a good address at 3319 Delmar Lane, Delmar. He lives with his father, Mr. Clarence Dozier. Mr. Dozier owns the home, and so he does have a strong property interest in his own house. My client has lived in Georgia his entire life. He's a Grady baby, Judge. He went to high school at Westlake High School in Atlanta, and afterwards, he did get his GED. For work, Judge, previous to this incarceration, he was working at Environmental Stone Works. He was there for about a year and change. It was a full-time job, and he molds concrete at that work. And Judge, not only does he have work ties, he does have other family beyond what I've already mentioned. His fiance has one on the way, Ms. Watson, and Judge, he has not only his dad, but his brother and his entire extended family in Georgia. It's my understanding that he has no extended family outside of the state, no passport, no passport, so he would not be able to flee the jurisdiction. And Judge, while Mr. Gray was not at the incident location when law enforcement arrived, when this arrest warrant was executed, he was in DeKalb County, so.
In custody in DeKalb County, or he was arrested physically in DeKalb County?
I will have to defer to ADA Abade, but I believe he was arrested. So Judge, a stone's throw away from this jurisdiction. Judge, I will also say this, as far as criminal history is concerned, again, I'll defer to the state, but my understanding is my client has one previous conviction from 2017. It is a burglary in the second degree. The court will be able to see on the jail screen that there is a hold for a violation of probation because of this new charge based on that arrest. This probation was handled mostly during the pandemic, but the conditions of that probation were to keep his job, pay his fine, and be at the home when house visits are done or when phone calls are made. Out of that $3,000 fine, he had paid up to $1,500 by the point of this arrest. And so, Judge, I would state to the court, it's my understanding that he has been compliant with that probation, and I'm not aware of any other felony convictions on his record. The pretrial report states very clearly my client's not on parole, that he does not appear to have 3 or more probation or parole violations, and does not appear to have 2 or more failures to appear in the last 10 years. And I think all those would show that Mr. Gray would avail himself very seriously to any court's instructions in this case. As far as intimidation of witnesses, Judge, I would state to the court again that all 3 deceased were people that my client loved and were close to. And Judge, I don't believe in the amount of time he's been incarcerated, which is on or around 30 days at this point, that any further contact has been made with any of the alleged victims, nor has there been any intimidation or anything of that nature. So at this point, Judge, we are asking the court to consider a reasonable bond in this case. I believe an ankle monitor is something that we are amenable to. We have absolutely no objection to be completely clear. The court is inclined to grant a bond in this case. We do believe that house arrest, Mr. Gray staying at his father's home and being under ankle monitor would prevent there being any other issues between now and when this case eventually gets tried. I will also emphasize to the court, Judge, this incident allegedly occurred on May 23rd, 2021, and there were no subsequent instances of criminal activity that I'm aware of that has been that happened between the time period of my client being arrested and coming before your honor. Judge, I do think, yes.
The reason why I'm turning my head is that the tickets that were issued for your client from South Fulton PD list a different address for him, 614 Camelot Drive. Why that versus the Delmar Lane?
Judge, I will say, without having spoken specifically to my client about that I don't believe that's his handwriting, and I don't believe that's his domicile. When I did speak to him at the jail, he did state the address where his father would be at.
The Delmar Lane.
Yes, would be the best location for his address.
Okay.
And Judge, I will also note, if the court would like to hear, that on the booking report at the Rice Street Jail, it does list 3319 Delmar Lane as his home address.
Okay. Thank you.
Thank you, Your Honor.
I'll make sure you can have the last word too, Mr. Cho. You'll be reacting some to what we hear from Mr. Abate. If you would, please, Mr. Abate.
Thank you, Judge. I would respect the request deny counsel's motion for bond for several reasons. I would simply support the defendant is a risk of flight. This incident did occur, as Mr. Cho said, on May 23rd of 2021. On that date, warrants for his arrest were issued.
So he was a suspect immediately.
Yes, Your Honor. And that was immediately turned over to the U.S. Marshals Fugitive Task Force. So warrants were, the defendant was not arrested until August 27th of this year. Mr. Cho is correct. He was in DeKalb County, but not in the custody of the Staff County Sheriff. He was at home hiding out, where it was clear that he had changed his appearance right after the homicide. He had longer dreads. At the time of his arrest, he had a very low haircut, according to the detective in this case, the Detective King from South Fulton, from the South Fulton Police Department. I'd also bring to the court's attention, he does have a failure to appear out of Rockdale County on a burglary charge back from October 5th of 2017. I'd also submit to the court that the defendant is a threat or danger to the people of the community based on the facts and circumstances of this case. As Mr. Joe did allude to, there is a third deceased in this case, Mr. Justin Santos. Mr. Santos or Mr. Gray is not charged with the death of Mr. Santos.
Was he also shot, Mr. Santos?
He was shot and killed, Your Honor. He was
Okay.
shot by the victim, Corey McDonald. So prior to this incident, a couple of days before, Corey McDonald and Justin Santos had gotten into an argument, as witnesses would say, because Justin Santos was abusing verbally and physically his pregnant significant other. Mr. McDonald had said that's not appropriate. You shouldn't be, she's pregnant, you shouldn't be hitting her regardless. That argument ensued and continued on this day, May 23rd, inside of Mr. Santos's home. At that point, there was a verbal argument according to witnesses between Mr. Santos and Mr. McDonald. And as Mr. McDonald was leaving, that's when he shot Mr. Santos and left to go to his apartment, which was just across the hall.
Literally across the hall?
Across the breezeway, I guess.
Okay.
There were apartments across from each other in the same building, on the same floor.
So he didn't go very far away. He went out one door and in the one across.
Correct.
Okay.
Mr. McDonald lived in that house with Ms. Denise Dupree and their very small child. After the shooting, Mr. Gray, the defendant, heard about the fact that Mr. Santos, they called him greedy, had been shot by Mr. McDonald. So
Did Mr. Santos expire there and then?
Yes.
Okay, so it was a fatal shot, immediately fatal. It wasn't that Mr. Santos called Mr. Gray to say, can you believe it? McDonald just shot me.
That's correct, Your Honor.
Okay.
10, 15 minutes prior to the shooting that this defendant was charged with.
Okay.
So word gets out of the apartment complex. Mr. Gray then goes looking for Mr. McDonald and didn't have to look hard because he was inside of his apartment. He can be seen brandishing a firearm through the breezeway. There's video surveillance. He goes into Mr. McDonald's apartment and you can't see the shooting, but obviously you can hear there's sound, him shooting Mr. McDonald. Miss Denise Dupree, his significant other, the significant other of Mr. McDonald, was standing in front of Mr. McDonald at the time that the defendant just opened fire on Mr. McDonald, shooting her in the head, where they both were hit, struck, and died basically immediately on scene. And that's when the defendant then fled the scene, Your Honor. The state would submit the defendant as a risk of committing felonies pending trial. He does have a prior burglary conviction out of Rockdale County from January 10th of 2018. And I apologize, Your Honor, I was just on Odyssey and he has 3 prior Fulton County cases. I was unaware of that. And so I wasn't able to look up the dispositions. They are all closed. I can tell you that there was a 14 SC 125663 possession of MDMA, which the defendant did receive a PTI, but there is also a 16 SC 142254. It's a criminal damage to property in the 2nd degree, and then a 14 SC 125831, which is a burglary in the 1st degree, both nonviolent offenses. I don't know the dispositions off the top of my head at the moment, and I can check back with Your Honor on those. But I would submit to the court that he's a risk of committing felonies pending trial due to his criminal history. And the risk of intimidating witnesses is similar to the other cases we've argued today. Video surveillance seems to be working better in all the areas of Atlanta. So a lot of this was also captured on video surveillance, which you can't intimidate. So based on that, Your Honor, we would respectfully request you deny defense counsel's motion for bond. Miss Denise Dupree's parents, Miss Joanna Dupree and Brian Pryor, are both on the Zoom. And when Your Honor is ready, we'd like to make a brief 50-minute statements.
Of course. You've shared what you want to share?
Yes, Your Honor, I'm sorry.
Okay, so Ms. Dupree, if you want to unmute, I would be happy to hear from you if you are comfortable.
Yes, sir.
Hello?
Yes, can you hear me?
Yes, ma'am.
Can you hear? Hello?
Yes, ma'am. Can you hear
Hello?
me? Hello?
Yes, I can hear you. I can hear
Okay.
you.
You're up.
I just want to say that I would like for you to deny the bond. I've suffered a great loss, and it's not like my daughter can come home on house arrest and be with her children, which there are 3 children that were left behind. And I understand that someone stated that the defendant's girlfriend is pregnant. My daughter was also too pregnant when he killed her. So with that being said, he sent me a message by the detective and said he didn't mean to kill my daughter. And I sent a message back. I don't believe that he did, but he still has to be punished. We have to accept what we do, our mistakes. And the fact that he came, if that was his best friend and he thought somebody had did something wrong, he could have called the police. But the fact that he took matters into his own hands allows me to believe that he should not be granted a bond. He should not be allowed the comforts of home, his father, his girlfriend, the upcoming baby. He should not be allowed those things because it's over for my daughter. My grandchildren will never see her again. I have a 2-year-old that asks all the time, where's her mommy? And point at her picture. Where's her daddy? And point at his picture. So I don't believe that he should be allowed any of those comforts because they're no longer available to me or my grandchildren with my daughter. I would like for his bond to be denied.
Thank you, Ms. Dupree, and I'm sorry for what you and your family are going through.
Thank you.
You're welcome. And sir, we have Ms. Dupree's father, I think, who wanted to be heard.
No, you have Denise Dupree's dad, Brian Pryor.
Right. That's what I thought I said. But either way, Mr. Pryor, are you there? Nope, I'm not hearing from a Brian Pryor, but it's good to know that he wanted to be heard. I suspect he'd be sharing some of the same thoughts and heartache that Joanne Dupree shared. And I appreciate his willingness to do the same. Mr. Cho, is there anything you want to add? Oh, Ms. Rolak.
I do have Mr. Pryor's statement.
Great. If you want to come up to the microphone and share that, I'm definitely ready to hear what he wanted to share.
Good morning, Your Honor, and people of the court. My name is Brian Pryor, Brian Pryor, father of Denise Dupree. My heart is heavy today because I was woken up this morning by my wife telling me that Quintavious Gray was asking for a bond hearing. I know there are certain legalities that have to take place in the court system, but I also want the court to know what the defendant has taken from us. Denise was not only my daughter, but she was also a mother of 3, a 12-year-old, 2-year-old, and 6-month-old who are totally aware that their mother is gone. My 2-year-old granddaughter throws temper tantrums and cries hysterically and uncontrollably, asking for Denise. I want Denise, or sometimes pointing to a portrait of Denise and Corey, sobbing uncontrollably until we pull her away, which we shouldn't have to. What's wrong with a 2-year-old looking at a portrait of her parents? Nothing, but in this case, a whole lot, because that's the only way she'll ever see her parents again, is through a portrait and the stories we tell her, including the horrific story as to why they aren't here anymore, because that story will have to be told. My 6-month-old cries and shakes uncontrollably because she doesn't feel her mother's warmth. Look into her mother and father's eyes, smell their breath, smell their essence. She knows that there's a profound void, and my 12-year-old grandson, who went to live with his father, is in another state and shell-shocked, sad, and extremely hurt because his parents were murdered, taken away from him, while also being separated from his sisters, whom he loves so much, and they love him the same way. They were a trio filled with laughter, joy, and happiness until Quintavious Gray came into their lives and shattered them. My grandson calls me on a regular with questions sometimes I can't answer, problems that I can't fix. My wife is totally heartbroken. Thank you.
Mr. Pryor, if you're on this call, I was able to hear all that, and I appreciate you providing that additional insight as to how difficult this has been for your grandchildren, your daughter's kids. Mr. Cho, anything you want to say to wrap things up?
Yes, Judge, thank you so much. Judge, I would like to extend my personal condolences to the family. I understand loss is very hard. I definitely sympathize with that. That being said, Judge, I will say this as well. My client denies these charges in their entirety. He denies doing anything beyond protecting himself and his own life in this case. Judge, I want to be very emphatic with the court in this case. It does appear very clearly, the timeline is that the first person shot dead is not a listed victim in this case. It does appear there is video camera surveillance I have not seen, so I don't know what the timeline is, but I think it's very clear that the proximity of the two incident locations are close, not only physically, but temporally as well. And I think that's very relevant in this case. And so, Judge, I will also just note one last thing factually for the court, that as far as this incident is concerned, the apartment where the two deceased who are listed in my client's warrants were found, there was another gentleman inside who claimed he was sleeping when the police arrived. There was another gentleman as well that's listed in the police report, but I don't have further information beyond that. So I'm not sure at this point what has led the state to take the warrants specifically for my client, but Judge, we are asking the court to consider a reasonable bond in this case.
Okay, thank you.
I hate to do this, I know he gets the last word, but his client admitted it in a statement that he shot and killed both of the people.
Okay.
And so that is one of your own, that's why we took out warrants.
Might have wanted to put that in the first time around, but that's okay. And Mr. Cho, you are exactly right that at this point, and I should have shared this with folks with our other bond hearings as well. Of course, Mr. Gray comes into this courtroom with the presumption of innocence in his favor. He's been arrested. That's an important and significant event, but he is presumed under our Constitution and the federal Constitution to be innocent of any allegations unless and until the state proves his guilt beyond a reasonable doubt or he enters a plea of guilty. And I don't know how this case will play out. The other thing I want to note is that it's not appropriate for me in considering bond, no bond, to think about would it be punitive in some way to keep someone in jail, because that would be a calculus that only applies after there's been a finding of guilt. And so I know some folks have said, Mr. Gray shouldn't be able to be home where it's comfortable. Look what he did. He should be in jail. A perfectly understandable sentiment, not what I should be thinking about. And I don't spend time thinking, well, the couch at home is more comfortable than the bed in the cell room. I should be thinking about what is Mr. Gray's risk of flight? What is his risk of committing other felonies, danger to the community, intimidating witnesses? This one to me is not particularly complicated based on the little bit that I understand. Even if there is an element of self-defense, even if there is an element of heat of passion, this is not someone who needs bond right now. I'm going to deny the motion. I don't think there's a set of conditions that I could impose that would keep the community safe or keep Mr. Gray out of trouble, given the discussion that we've had today. Of course, Mr. Gray remains in an unindicted status. And so, Mr. Cho, it may be that we need to revisit this after 90 days have run. But at this point, I don't believe that bond is appropriate for Mr. Gray. Thank you. And Mr. Cho, if that is your only matter, you are free to go once you, assuming Ms. Bray doesn't need the backup since she's coming in, just getting to know her clients. I'm gonna find out in just a second. Ms. Bray, are you wanting to move forward with Mr. Smith? Should we bring Mr. Smith out to say we'll see him soon? Because he would be next up, and then we get to Mr. Alan Jones.
I would rather bring him out so that we can say we will see him soon. I do believe this is going to be an ex parte. I just need to know if do I file that with you or do I do it with the?
You do it with me. And ex parte as in someone needs to go meet with him.
Yes.
Yep. So I'd be the one who'd sign it, given the nature of the charges.
Yes. Okay. So I just
think
want to be
that's right.
sure.
I've never had that come up.
Going to be Ms. Borski, Judge Borski, sorry.
I'll sign it because it's not going to be a non-complex case in the end. Either it's charged with murder, so there may be competency issues, and it may be that it goes down a different route. But if the state ultimately indicts it, it's not going through non-complex. So send it to me, and I will sign what needs to be signed. So we can bring Mr. Smith out. Should he just stay right there at the door? Why don't we keep him right at the door? You don't need to take this down.
There is a video according to 8805 of the incident. I'd like to see that video.
Okay. Hey, Mr. Smith, you can come out a little bit more just so I can see you. Can you see me? Great. I'm Judge McBurney. Nice to meet you. So, Mr. Smith, I was just chatting with your lawyer, Ms. Bray, and we were, hold on one second. There we go. We were originally going to talk about bond. You good? Okay. We were going to talk about bond, but I think it's important that before we have any discussion about your case, that you spend a little bit of time with some folks that I'm going to ask come talk to you at Rice Street. After you've had that conversation, we can get you back here. Either you'll come via Zoom or we'll bring you over here and we will talk about bond. But I'd be more comfortable having any discussion with you about this case. It's a pretty serious charge. After you've had a chance to talk with the folks who I'm going to ask to come talk to you at the jail. Will you be willing to talk to them if they show up? It's not no one from the state. It's not prosecutors, it's doctors. Okay, great. Thank you, sir. Appreciate it. So Ms. Bray, you will get to Ms. Nelson, whatever paperwork you'd like me to consider. And if it's appropriate, I'll sign it and that'll get that rolling. Okay.
Mr. Rod, do you have the video?
I don't. I'll work on getting it. I'll work on getting it. I don't have it.
Because the incident report I have is just one paragraph.
I'll get you some more stuff.
Okay. We'll just want to get something ideally to the medical professionals. Yeah, exactly. So they know what they're engaging him on. But we've got time. I mean, you got to get me that paperwork. They don't show up right away. So just you keep bugging Mr. Abate. He'll get you something.
I'll get it. You bug away, I'll get it.
Mr. Francis, it is time. We're not bringing Mr. Alan Jones out first. I want to just get a couple things from his lawyer and then we'll figure out if he's coming out. Did you mean more of a, I didn't mean to rush you. You're good? Okay. So we can get this on the record in a minute. But Mr. Francis, we received communication from the jail that your client was not going to be brought over today because of a quarantine situation. I'd rather not err and have him come out here. It may be that they mistook where he was housed. I just was real surprised when I was talking with Deputy Holt that he was here today. And so my thought is, unless you are going to unwaive his presence, we don't have him come out here. And we have the discussion. He was not going to be able to zoom in anyway, so he's not missing out because he was brought over. This was an in-person calendar only. But I want to get your thoughts on that.
Well, we had hoped that he would be present, if not here today by Zoom. Since he's here, of course, his mom is here, she'd love to lay eyes on him. I understand that.
Sure.
And I think there was a positive test, and we want to bring that up as part of this talk.
He tested positive, or okay?
Yes, since he was brought into the jail, had a cellmate who tested positive, and then soon after that, Jacob started to exhibit symptoms. So then he tested positive, so he is under quarantine. So I certainly understood that's why he wasn't being brought over.
Yes.
So, and you got to run your court. So
I do. Okay.
my mom would love to lay eyes on him. But we understand the decision that you made.
Understood. Well, I appreciate you sharing that additional piece. It's not just that Mr. Alan Jones was in a pod or a cell where there was a positive, but he himself has tested positive. So he's going to stay back there. But that doesn't mean that if we're having a follow-up discussion, we couldn't figure out a way for him to be in one of the Zoom booths out at the facility. And if you want to speak with him when we're done, you're more than welcome to go back there. Okay? So let's get on the record. This is position 5. It's State versus Jacob Allen Jones. Jacob is Jaycob. And we just had an off-the-record discussion about Mr. Allen Jones being physically present in court. He is in the building. He is in lockup in the building. His attorney, Mr. Francis, has indicated that Mr. Allen Jones, since being arrested and held at Rice Street, has tested positive for COVID. So I have decided that he is not going to be brought out into court. It's my understanding that Mr. Francis had waived Mr. Allen Jones's presence if it ended up being the case that Mr. Allen Jones could not be brought over. The surprise is that he was brought over, but I am deciding that it's not consistent with public health guidelines to have a known positive who is still well within the quarantine window to be brought into court. So he is nearby, but he is not physically present. And Mr. Francis, I want to give you the opportunity to say, we'd like to reschedule. And we could do that and either figure out a way to have Mr. Allen Jones beamed in through Zoom, or we could get a date when he is post-quarantine and have him brought over and do this in person. I'm okay with any of the three, moving forward as is, or delaying for either a video link or an in-person visit.
We would like to move forward as is.
Okay, we'll do that then. Mr. Francis, when you're ready, and you're welcome to give your presentation from there, you just need to be closer to the microphone so that we know Ms. Rivers is able to hear everything you've got to say.
Okay, I'll stay here, Judge, as long as you can hear me.
I can hear you, and with the mask off, we're good to go.
Okay, Judge. Well, Jacob Allen Jones, who would be here for you today, he's 19 years old. His mom is in the courtroom here today. Devon Allen is in town. And a close friend of mom is Paula Kennedy. Is that right? She's here too, supporting Ms. Jones and supporting Jacob. Judge, he has two cases. He has the murder case, of course, and he has an armed robbery case. And I sort of wanted to go through a little bit of my understanding of those two cases first.
They are, as far as you know, unrelated?
Unrelated, right. And let me say this about the armed robbery case. He is charged with armed robbery. It is not stranger on stranger, okay? It is someone that he has known for some time in the neighborhood. And the co-defendant on the murder case is also charged with armed robbery. My understanding of the armed robbery case is that a young man who was about 19, who was a local marijuana dealer, was showing off, brandishing his handgun and showing it off, and also showing off a lot of money that he had. And subsequently, I believe the co-defendant struck that victim with his handgun and took the handgun away from that victim, and that money was taken from the victim. But then subsequently, the victim appeared at Mr. Jacob Allen Jones's home, and his money was returned, is my understanding. He was not, Mr. Allen Jones was not arrested.
So it was a temporary armed robbery.
Exactly. He was not arrested by the police officers because it's my understanding that the victim in that case did not want to cooperate with the authorities. And he told his mom what happened, and that his mom called authorities, but that he did not want to cooperate with authorities. So authorities came to Mr. Jacob Allen Jones's house, but he did not get arrested. It was not until the warrant goes out for this murder case where he was arrested on the armed robbery, in charge of the armed robbery case as well. So it's not our classic armed robbery that we see here in Bolton County. It's a little bit different. So I just wanted to point that out. What I understand from the murder case, from the warrant, is that this may have been a mutual combat situation where people were taunting each other and challenging each other to a fight, and people started to place hands on weapons, and then shooting occurred as a result. There may have been someone on, one of the co-defendants may have encouraged another co-defendant to shoot at someone, but that even after that, there may have been what we would characterize as people engaging in an argument, which led to possible fisticuffs, which led to guns coming. There may be a video of this from a neighbor's Ring camera, I believe, which I don't believe shows my client firing the fatal blow on the victim. So that's my understanding of those cases. And of course, at the end of this judgment, we're going to ask for a bond in the amount of somewhere between $25,000 and $35,000 for both cases, including an ankle monitor.
So there is a CP out there for the armor. It's not on the calendar. I'm fine that we're talking about it, but there is a, despite not having been arrested at the time.
There's a CP case.
Okay.
My understanding, once he was arrested, he had that case.
Okay.
Just at the age of 19, he has no felony case, which we give him a few years from turning 17. There is some juvenile history and apprised of that. But for all intents and purposes, he's been a good kid. His mom is very engaged, and he wouldn't live with her. Now she still resides in the area currently, but if he were to be granted bond, she's going to move. But he would not go back to that neighborhood. He would go to a separate area.
Was Mr. Allen Jones living with his mother at the time of this incident?
Yes.
And is that somewhere around the Manchester apartments?
Yes.
And that's where mom lives now,
Right.
but she would move if her son got a bond so that he is, or regardless of whether she's moving.
She's moving regardless. But
Across the street or far, far away,
Far away,
but not to California.
not California, in the local area.
Okay.
He would not go to that address if he were to, let's say hypothetically, he were to be released from. He would not go to that address. He would not go
Correct.
to that neighborhood. He would go probably to Lawrenceville, to family and friends, stay there until mom can move, which she thinks she can move in about a week. Is that correct? She thinks she can be out of there in about a week.
Okay.
She also wants to get him in the next level Boys Academy, which is a program designed to help young men like Mr. Allen, and we're in the process of talking to them about entry into that program. She has reached out to them. He has a brother that's here, and he has an older brother that's here who's doing well, and he's got family support. And I think he would be a reasonable candidate to appear at any court appearance. I would say myself, I would make sure he was here. If I had to go pick him up myself. I haven't had the experience in my career of clients not showing up for even the most serious charges, even murder charges. Clients on bond. I don't have a recollection of us not being able to locate a client who's on bond for a murder charge.
Are you, Mr. Francis, expected to be staying with this case, or are you on this case for bond purposes only?
Yeah, I never understand how lawyers did that in the first place.
Me neither, but it happens.
I've been for 20 years. I don't understand it. You're in the case, you're in the case. You know, so I'm personally invested in the case.
Okay.
So I'm here. And I will be here. And I take it, you know, I'm only on cases like this where I feel as though I can help a young man. And I feel as though this is a young man that can be helped. And I feel as though this young man, after getting to know his family, will come back to court. I would personally make sure that he comes back to court. And I know mom will make sure that he comes back to court. And mom's friends and family will make sure he comes back to court. But we understand there are very serious charges. We understand that. But I think given his age, given the fact that he went in without COVID and now he is COVID positive and is quarantined, I think it's safer for him to be out. I think he can work when he gets out. He indicated that he would seek employment with work for DHL, which is a warehouse job. He can go there.
He was doing that, or this would be a new job
Be a new job.
that someone has lined up for him?
Exactly. This would be a new job. And if we can get him in the next level boys academy, I think he would be a reasonable candidate to return to your court for any upcoming court dates. Now, with respect to the intimidating witnesses, he knows the victim of the armed robbery case. Yes, that's true. But we would get him far away from that location. And I think that, in today's electronic age, I think we would know immediately if there were any phone calls or any communications between the two parties. And with an ankle monitor, we would know he was anywhere close to that neighborhood.
The alleged victim in the armed robbery sounds like it's a little more than alleged, but either way, that person is not anyone associated with Luther Martinez, Victor Lazo. These are the people who were part of this. You're describing as mutual combat, whatever it was. Separate situation.
Right, we would defend that as, and that my understanding is a separate situation.
Okay.
I have not been provided with any. Judge Mom is here, and if you have any questions from her, she can certainly be willing to answer those questions. But that's essentially our presentation.
Okay. Had Mr. Alan Jones been working before? You said maybe a job should he get out,
Mattress Firm, he was at Mattress Firm.
but how long ago was that?
Probably 2 months.
2 months prior.
How long had he been there?
About 6 months.
Okay. And did Mr. Alan Jones finish high school? You may have already said that, or he has not. He was in high school, didn't finish, doing his own thing now. Okay. Keep muting these iPhones. All right, Mr. Abate.
Thank you, Judge.
And just so you both know, I listened to Mr. Francis, there is an affidavit that's like 2 pages long, that's part of the commitment. So I've just been trying to catch up with the mutual combat and what's alleged. So I've been skimming that. That's how I got that name of Luther Martinez and Victor Lazo. That's all I've got in the case file anyway. So when you're ready.
Thank you, Judge. At this time, the state would respectfully request you deny defense counsel's motion for bond. As Mr. Francis did state, there is a juvenile history. I don't have the specifics of that. I was still waiting for an email from our juvenile department to provide me with the details of his juvenile arrest. I was able to see from his criminal history that he had been arrested as a juvenile, but that was it. No specifics.
It doesn't say what the charges were for the arrest. I don't know what that looks
It
like.
doesn't. It just says a juvenile arrest.
Okay.
I would submit to the court that the defendant here before you is a threat or danger to the people in the community or of the community, as well as a risk of committing felonies pending trial, based on what you've heard today from defense counsel alone. That on July 9th of 2021, he was in the same complex with his co-defendant, in which an armed robbery occurred against the victim. I understand Mr. Francis' recitation of what precipitated the armed robbery, but when speaking with the detective, it was the two defendants approached the victim who was getting into his vehicle with $250. They kind of entertained a conversation, and at that point, that's when the defendant's co-defendant came up, and he was pistol whipped or hit with a gun by each one of them, and they took $250 out of his vehicle and then fled the scene. That was my understanding of what occurred. He had the $250 because he was going to get a tattoo.
Trying to go back in and type in the code.
Hold on one sec. I wish. Okay. Keep going.
As well as this incident, which occurred about a month later on August 19th of this year. My understanding of how the event.
Same apartment complex, different apartment complex.
Same apartment complex.
So this Manchester apartment complex is where the shooting happened. It's also where the armed robbery happened.
Yes, Your Honor.
Okay, and I think I heard Mr. Francis say this. Does the co-defendant have a last name that you know?
Yes, his last name is Hayward.
So Mr. Hayward and Mr. Allen Jones are purportedly involved in the armed robbery. The victim says, no, they both hit me with guns.
Yes.
Fast forward, not all that long, Mr. Hayward and Mr. Allen Jones are back in the same apartment complex. And by my read of the affidavit, they again both have guns.
Yes, Your Honor.
But instead of pistol whipping people this time, the guns are used as they're designed and they are fired.
Yes, Your Honor.
Okay.
In this incident that occurred around 10:30 p.m. on August 19th, Luther Martinez was outside waiting for the victim, in this case, Mr. Victor Lazo, to come home. They were planning on hanging out, and so he was just waiting outside for Mr. Lazo. At that point, that's when Mr. Allen Jones and his co-defendant, Mr. Haywood, did approach Mr. Luther. There was a brief conversation. Then Mr. Luther told the detectives that during the conversation, both Mr. Hayward and Mr. Allen Jones kind of challenged him to a fight. Mr. Luther said he knew that Mr. Lazo was coming soon. He tried to hold them off. And that's when Mr. Lazo did arrive. He approached the circle of young men. And at that point, he was able to, when he approached, that's when one of the co-defendants, and I apologize, I don't know which one, was brandishing a firearm. And that's when Mr. Lazo did pull out his firearm, and then shots immediately began to be fired from the co-defendants, Mr. Haywood and Mr. Allen Jones. There is a cell phone video from a resident of the apartment complex who was able to capture the shots, not the actual shooting, but the noise of the shots. There were several shots in rapid succession, and then no more shots. And then the two young males running away is caught on scene. What the witness did see was the victim, Mr. Lazo, trying to duck between cars, but was unsuccessful and was hit multiple times and died on scene, from what my understanding is, Your Honor. They were able to get, and I believe it's from the video surveillance of the gate of the apartment complex, a gold Chevy Impala leaving the scene. They were able to get the license plate and were able to track it back to Mr. Hayward's mother. At that time, they were able to put, because of the connection between the gold Impala and Mr. Hayward's mom, they made the connection from the armed robbery that happened in July. They put both Mr. Haywood and Mr. Allen Jones in a photo lineup, to which Mr. Luther was able to identify both defendants as the individuals who challenged him to a fight and shot Mr. Lazo that evening. As to the risk of intimidating witnesses, as Mr. Francis did indicate, there is some sort of prior relationship or communication with the armed robbery victim. I don't have any evidence to show that Mr. Allen Jones has made any contact to the victim in that case. So I believe that factor is not implicated here, Your Honor. But based upon that, the state would respectfully request that you deny defense counsel's motion for bond, as the state would submit to Your Honor that the defendant is a threat or danger to the community and the people in it, as well as a risk of committing felonies pending trial. And I believe the victim's mother is on the Zoom and would like to briefly address Your Honor.
Sure.
Marjorie Jimenez is her name.
Ms. Jimenez, if you can come off of mute.
Ya está, ya está. Good afternoon, Your Honor. How are you?
Hey, I'm well. How are you?
I'm good. Thank you for asking, and thank you for giving us the chance to speak.
Definitely. I am here to listen. So I don't know if is this your mother?
Yes, this is my mom. And
Okay.
I'm Victor's younger brother.
Okay, and your name is?
My name is also Victor Lazo.
Oh, same name.
We have different middle names though. He was Victor Jose, I'm Victor Jesus.
Okay, I'll call you Mr. Lazo. Mr. Lazo, are you going to be translating for your mother, or is your mother?
Yes, sir, I am.
Okay, can you give me your mother's name?
Her name is
Marjorie Jimenez.
Great. Can you spell your first name, please?
Yes, Maryury, Marjorie. My last name is Jimenez. It's a Jimenez, Jimenez.
Ms. Jimenez, thank you for being here. I know it's been a long wait. I didn't realize it was already afternoon, but these are
Thank you.
important events and they take a little while. You are welcome to share with me what you want in English. If you prefer to speak in Spanish and have your son, Mr. Lazo, translate, that's fine too. We just need to know the way you want to do it so the court reporter knows who to listen for.
Thank you, sir.
So,
I appreciate that, Your Honor. Yeah, yeah.
Okay, so she's just gonna speak and I'll translate.
Great.
Gracias por la oportunidad.
She's saying thank you for the opportunity.
Solo quiero decir que extraño mucho a mi hijo
She would like to say she truly misses her son.
y que es un dolor que nunca voy a poder quitarme de mi corazón.
She says that it's a deep pain that she knows that she's going to have to live with for the rest of her life.
Que yo no tengo odio ni rabia en contra de estas personas.
She wants to know, despite the pain that she feels, she holds no hate, no anger, nor resentment towards the men who did this.
Yo creo en Jesucristo.
She says that she believes that Jesus Christ is her Lord and Savior,
Yo los perdono.
and that she forgives them.
Pero a mí me gustaría, por favor,
And she would like, oh, but dilo todo.
I would like to request you.
No, dime a mí.
Yo quisiera que no le dieran un bond ni nada. No merecen estar fuera de la calle ninguno de los dos.
She says that despite her forgiveness and the pain that she feels, that we all collectively feel, and this is my younger sister as well, and this is the court, and she's saying that they don't deserve that bond.
Mi hija,
That, yeah, they don't deserve to be free.
mi hija vio a sus 17 años cómo mataron a su hermano.
She's saying that my sister got the worst out of it because she actually saw them shoot my brother. She saw my brother hit the ground and everything.
Y mi hijo Víctor Jesús y yo
And me and my son, Victor Jesus, and me,
lo recogimos del piso
we picked him up from the ground together.
y murió en nuestros brazos.
And he died in our arms. And we commended his spirit to the Lord.
Nadie merece
No one deserves
morir a manos de otra persona porque se cree muy valiente porque tiene un arma en las manos.
no one has the power to take another man's life, regardless of owning a weapon and, feeling mightier than the man just because, you have a piece of metal in your hand.
Yo supongo que, bueno, existe la justicia del hombre.
And well,
Sí, existe la justicia del
she would
hombre.
like to believe that justice exists.
Y existe la justicia de Dios también.
Yes, that the justice of man exists and that the justice of the Lord exists as well.
Y si ellos decidieron
And if they chose,
vivir,
di la oración completa.
si ellos decidieron vivir esa vida, no es mi culpa que ellos decidieron ser asesinos.
It is not our fault that, these two young men decided to live their lives like that and make the choices that led up to this very moment. And my brother didn't deserve that.
Nadie es.
No one deserves that. No one deserves that.
Right. Mr. Lazo, how old was your brother at the time?
He was 27 years old. He's going to turn 28 on the 15th of October.
And how old are you?
I am 20 years old.
Okay. Well, thank you very much for serving as a bridge between me and your mother. She has a very, very big heart to already be thinking about forgiveness because the loss is great. And it sounds like it was particularly difficult because you were able to be there in those final moments, which is both a blessing and it's a burden you'll be carrying with you for the rest of your days. So I appreciate you waiting to speak and I appreciate you sharing what you did.
Thank you for giving me the opportunity to let
Thank
us know
you.
how you feel.
Thank you, Your Honor.
Thank you.
¿Quieres decir algo?
You're welcome. All right, I'm going to put you guys back on mute unless there's something else you want. You took care of it. All right, thank you. Mr. Abate, do you know if Mr. Hayward is in custody?
Yes, I believe he is, Your Honor. I can check in.
It's not critical. I mean, there are efforts underway to move his case forward as well. Yes, okay. And then second, is there evidence that shows that both Mr. Hayward and Mr. Allen Jones were firing, or there was this exchange of words and let's fight? And you mentioned a cell phone that records the gunshot so you can hear gunfire. I'm just curious if there's anything that would show if everyone had guns or just Mr. Hayward or just Mr. Allen Jones or what?
And all came to the court. From what I understand, there's evidence by a witness who would testify that both of them have firearms, but I can't say definitively at this moment if both of them fired. I know the ballistic books were collected and will be tested on the GBI, which will help with that determination. But as of today, I can't tell you that both individuals were firing.
But at a minimum, the evidence, as you understand it, would show that both Mr. Allen Jones and Mr. Hayward were brandishing firearms in a gunfight that resulted in Mr. Lazo's death. Okay, all right. Mr. Francis, anything you want to share in summation?
I'm not sure if I understand that correct characterization from the warrant. And you heard the summary of the warrant. The warrant is often written in the light most favorable to the victim. I thought I heard, what I read in the warrant was that they thought someone reached into their pocket and obviously grabbed a gun, but that Mr. Luther Martinez actually brandished his weapon and asked the other two to leave. And then after that, then guns came out and shots were fired. So that's why I asserted in my initial statement that we would be asserting mutual combat, because there's no allegation that this was an attempted armed robbery, this was an aggravated assault, or this was any other type of encounter other than, because what I've learned is that this was an encounter over a young woman who was being approached by, I think, our side and being defended, so to speak, by the other side. And then words were exchanged, fists came up, and then guns came out. So I think it's a little bit different than the last characterization, that it was just guns brandished by our side. I'm not sure if they were actually brandished by our side, other than they assumed that, and which turned out to be correct, that they had their hand on a weapon, and one of them had their hand on the weapon inside of their pocket. But that is clear from the warrant that Mr. Martinez did pull his weapon out and demand that our side leave.
Okay, I'm reading in greater detail now.
Okay.
So,
And there were some, words were exchanged.
sure. So there is a gentleman with a red hoodie. This would be on the Hayward Allen Jones side. There's a guy in a red hoodie and there's a guy with, I think it was white shirt and black pants with short dread. Let's see. White shirt, black pants in his mid-20s, and then a guy with a red or red and black hoodie with the hood up. Any sense of which was which?
I can't tell.
Okay.
But if you got 9 lines up from the bottom, it's Mr. Luther says that one of the men was clearly holding a gun.
No, I see that. It sounds like Red Hoodie had the gun, and several people say Red Hoodie was shooting. And I'm just trying to figure out which one was Red Hoodie.
Oh, but we understand from.
Oh, now you know which one is Red Hoodie.
We understand from some video that the shooter, I can't say what they had on, but the shooter was not Mr. Allen Jones.
Okay, then presumably it's Mr. Hayward who had the red hoodie on. Okay, okay. Well, and who knows?
I read it to say that he had 10 in his pocket, clearly holding the gun, not that the gun was out.
Well, it eventually came out.
Regardless, the implication was that he had a gun, and they strongly understood that he had a gun, but that a gun came out by the other side, and the order for them to vacate came from the other side.
That's what I'm reading here too, that told people to leave and then they started shooting. Okay. All right. So Mr. Francis, at this time, I am not going to set a bond for Mr. Allen Jones for a couple reasons. One of which you may want to address again. But I am concerned about the staying out of trouble and safety of others. It's two factors, but they're often intertwined. It's not risk of flight. Partly because of your representations, but mom is here, there's a home for him, et cetera. Although I'll note that the home where he was living was where a lot of this happened. And I appreciate there'd be a new residence in the near future. But these two incidents, both of which allegedly involved guns, one of which could have ended up far worse than it did, that would be the armed robbery, one of which resulted in someone's death, and it sounds like could have involved Mr. Allen Jones's death if in fact bullets were flying across this parking lot. And any of those outcomes would be tragic. Sounds like a scenario where someone who had nothing to do with anything could have been shot, and it only amplifies the tragedy of it all. But those two things happening so close in time, involving guns and whatnot, make me not comfortable that just relocating with mom would keep Mr. Allen Jones out of that kind of activity, out of that mix, and frankly, out of harm's way, because either of those situations could have ended up with his life being lost as well. He's young, and it sounds like impulsive based on what we've discussed today, and that doesn't go away just overnight. And I'm not comfortable that even if Next Level Boys Academy gets in the mix, that's gonna keep Mr. Allen Jones away from things he should not be involved with. And I'm not saying Mr. Hayward was the bad influence on Mr. Allen Jones or vice versa. Clearly, the two of them together, bad things were happening for folks in that community. And that is why I don't think bond is appropriate at this time. You will no doubt learn more about the case. And if it comes to your attention, Mr. Francis, that there is a different narrative for either or both of these, where you think it is pretty clear from things we are able to discuss that Mr. Hayward is a mover and a shaker and Mr. Allen Jones is a follower, maybe we should discuss again. But followers who are also carrying guns are subject to the same concerns that I've got. And so everything I'm hearing and reading in connection with the murder, I haven't looked at all at the armed robbery, although I now have the CP number, suggests that Mr. Allen Jones had a gun as well. And it's just a mess he needs to not be involved with. So whether it involved the girl or this or that, and whether there's a defense of mutual combat, all may be true, but they don't lessen my concern for the safety of the community.
Your loyalty should.
And Mr. Allen Jones's ability to stay out of trouble while he's on bond. So that's my ruling for now. The 90-day mark is not far away, and so we need to reconvene at that point, if not before. But if you feel like you learn more about the cases, and I mean cases, or you believe that there is some set of conditions that you're thinking about, but you haven't been able to lock in that materialize, we should talk about this again. But either way, we'll need to talk about it again when we hit the 90-day mark, if this has not been indicted. Okay. Mr. Abate, anything else? All right, thank you. So we should, is Miss Mattel still here? Or if she stepped out? Is Miss Patel still around? Do you know?
I think she stepped out and did a code.
Good, she should get it, because we've got Mr. Hambrick, and then we have our Faretta hearing.
Yes, I'm in the back.
Oh, good, you should stay. I wanted to acknowledge you being here, and I appreciate that. These are taking a little bit, so we're gonna see what we're doing with Mr. Hambrick, and then all we've got left is Mr. Williams.
Okay, great.
All right? And Debbie Holt, maybe you can tell me, you said you've got, you had 7. You have 7 inmates, or you have 8? 7, then they're all accounted for. Okay, great. So Hambrick is next, I think. What are we doing with Hambrick?
We're gonna do something.
We're gonna do something.
We're gonna
So
do it.
when you're ready, we can bring Mr. Hambrick down.
I'm ready.
You want to take a break?
I'm just standing up.
Okay.
We'll finish with Hambrick, then we'll take a little break, and then we'll do Williams.
Okay.
And Williams is gonna be a whole different affair. Anything remarkable happened this morning, Mr. Abate, over at Judge Glanville?
Not at all, Your Honor. Very quick.
Just not guilty.
Yes.
All right, Ms. Rivers, you ready? Our final position on our bond calendar is State versus Quintavious Hambrick, 21 CP 202748. Good afternoon, Mr. Hambrick.
Good afternoon.
How are you?
I'm okay, yourself?
I'm okay also. Mr. Hambrick, you have been arrested for murder, and we're going to talk today about bond in your case. Ms. Bray is representing you for now. I had a quick conversation with Ricky Richardson. He showed up. He was listed initially on the calendar as your attorney, but he said he's been asked to roll off the case. So he is not here. If you were expecting Ricky Richardson, he said he's not your lawyer anymore.
I don't really know what's going on. I was talking with my mom because I had a public defender to come see me at the jail when I was downstairs. And then I spoke with my mom and she said that I was supposed to have another public defender, so I really don't know what's going on.
Well, the public defender is a big office and different lawyers plug in at different times. They're all part of a team. So it's like if you were at the hospital and Dr. So-and-so works with you and then a different doctor. So the fact that you have met different public defenders is not remarkable. That's normal. I just need to make sure you knew that for whatever reason, Mr. Richardson had briefly been on the case. He is not a public defender. Someone pays him. I don't know who it was in your family who did, but he was on the call first thing this morning to say, I've been asked to get off, and he has withdrawn from your case. So Ms. Bray is going to talk to me about bond for you. You may work with her some more. Ultimately, if your case gets indicted, Ms. Bray will not stay with it. She handles cases before they're indicted. Once you're indicted, if you are, it'll be assigned to a specific judge. Could be me, could be one of 14 other judges. Each of those judges has a set of public defenders, and your case would go to one of them. And that would be your lawyer through the finish, whatever happens with your case. Does that make sense?
Okay.
If you got questions, I'm happy to answer them right now. You got it.
Yes, ma'am.
I'm impressed Your Honor has it. You got it.
All right.
But that's how we work.
That is how you work. I've learned. It's only been 10 years. So, Ms. Bray, tell me about Mr. Hambrick and why you think he ought to get a bond.
All right, Your Honor, you have before you Mr. Quintavious Hambrick. He is 34 years old, will be 35 October next month. He is a lifelong resident here of the Metro Atlanta area. Prior to his arrest, he was living at the incident location, which is the 3170 Imperial Circle, Atlanta, Georgia address that's listed in the warrant. He lived there with his mother, Belicia Hambrick.
That is both home and where whatever happened. Okay.
Yes, this is where it happened, Your Honor.
Okay.
He attended Creekside High School. When he can work, or when he was able to work, he worked in the home maintenance industry. I don't know if Your Honor was aware, but when he walked out, he limps. You know, there's an issue. Apparently, when he was about 21, he was shot 10 times. So he has like a rod and some things going on with his leg, which makes him less physical in movement, so to speak. Okay. Than others. And I do know that he is attempting to do his disability paperwork and get that started because it is hard for him to work in the physical condition that he is in. I believe present at that home also was his niece, Danisha Hambrick, and his nephew, Deshaun Hambrick, as well as a great nephew who was like a 1-year-old who is the child of the niece. And I believe they all live there at that address.
Yes, coming and going, yes.
So most of the time they do though? Okay, that's what I was told. So he has ties to the community, Your Honor. He has a stable address. I mean, unfortunately, it was the incident location, but he has a stable address. He has relatives and family that are here. With regards to likelihood to reoffend, I went through the GCIC. This arrest makes his 7th arrest. I did not see a disposition for the 6th arrest. So we would need to hear from the DA regarding that. I'm not sure if that's open or if that is a matter that has been dealt with. I just know that I could not make out what was going on the GCIC as far as that was concerned. I do know that he has used his first offender, Your Honor, and it was for a case that originated in 2006. Started off with really, really big charges that ended up being no pros. And he ended up having an ag assault that was reduced to a battery, and he pled on the first offender to that. Now, probably because he sat some months because the charges, the original charges were so big, like armed robbery, kidnapping, etc., but they ended up being no pros. So he used his first offender on a misdemeanor battery. That is my understanding. Then there was a fifth arrest that were, again, started off with a gun charge and some drugs, but somehow it was all transferred to state court in 2010. So it's only the sixth arrest that I don't know what happened on that one. So I think that if he were released, if he did receive a bond, Your Honor, that it would be a safe bet that he would not pick up a new offense or anything of that nature. With regards to intimidation of witnesses, Your Honor, incident location paperwork I have all shows, as I said, that it took place at the home where he was living. The mom is a witness. The niece is a witness. The nephew is a witness. The decedent in this case is the father of the niece's 1-year-old son. Briefly, there was an argument that took place between the niece and her child's father. It became physical. The DA is aware that the child's father, the decedent, grabbed her by her hair, was attacking her, managed to pull her downstairs, pull her outside of the house. Mr. Hambrick's mother was trying to prevent the decedent from attacking the niece. I understand from Mr. Abada, at some point, she's trying so desperately to stop him from attacking the niece that she might have picked up a pot or something and threw it and struck him with it. He in turn wants or tries to attack the defendant's mother, Mr. Hambrick's mother. That is when the shooting took place, Your Honor. The charge as listed is murder, but I do think that once more investigation takes place, more things go on, I do think that charge, if in front of a jury, that he wouldn't be found guilty of murder, that it would be more along the lines of voluntary manslaughter. It could be, jury could believe that it's truly defense of others based on what Mr. Quintavious was thinking at the time it took place. So I did ties to community. Okay, also, I do believe that there's no danger of a flight risk for him because he stayed on scene. So this isn't a question of who did it. Like we know. And so I am asking Your Honor to set a bond on his behalf. And yes, yeah, I am asking Your Honor to set a bond on his behalf. Would Your Honor consider, since it's the one charge, would Your Honor consider, and I do think it's a defense of others type case, would Your Honor consider a $20,000 bond for this one charge?
And then
You just have one
home
charge,
would be
right?
back at Imperial,
Yes.
would be back at Imperial Circle because that's the stable residence.
Yes.
How do you work through concerns about not
Then,
contacting, if mom is a witness, niece is a witness?
well, thought Your Honor was gonna say intimidating a witness, but on this incident location, those people that you've just mentioned, they've already given their statement to the detective.
Okay,
So whatever they've said, whatever their version is, they have it. So Unless the DA can say that he has phone calls or has listened to phone calls where my client is trying to convince his mom to change a story or convince his niece or nephew to change a story, that's, I think what is, they've already said it. So I don't think that there's a danger for him to intimidate them or to make them change anything because it's too late at this point.
Okay. Have you talked to Mr. Hambrick about whether there's any other place he could stay than in the household with all the witnesses?
Okay, hold on.
You could, why don't you ask him while I hear from
will
Mr.
ask, but I do know, and I want to point this out, his mom is very, very, very concerned. She emails me 2-3 times a day.
Concerned
So
about,
part of it is that he is not getting his medication or the proper medication at the jail. You know, I'm not a doctor, so I can't say what's his proper medication, what isn't his proper medication, but that's her concern, that he's not getting the medication he was on prior to this happening.
Mr. Hambrick, what do you take medication for?
Mental health, my mom can speak better about it. I let her operate all that, but
Right.
Okay, so you're getting some medicine, but it may be different medicine than what you used to take?
I'm not taking no medicine now.
Okay,
And that's what the emails are about, that he's not
Got it.
getting any of the stuff he's supposed to have.
understood. Okay,
But I do believe, based on communication with the mother, that if that's the holdup, that he not be back at that house, that I know there has to be another relative, another
Okay.
place where he could go. And
Okay.
we could get that information to the court.
understood. Thank you. Mr. Abate,
Yes, Judge. At this time, the state would respectfully request to deny counsel's motion for bond. As Ms. Gray did indicate, the defendant did remain on scene, so I have no concerns as it pertains to risk of flight. It would be inauthentic for me to make any sort of argument based on the facts of the case. I would submit to your honor, the defendant is a threat or danger to the community and the people in it. As Ms. Bray did indicate, there was a domestic argument between the victim in this case, Mr. Dominique Sanders, and his significant other, who is the niece of the defendant. He did pull her hair, and the incident or the DV exchange did go outside where the defendant's mother did follow. The defendant's mother did throw a potted plant at the victim's head, which he swatted her back, and I believe she fell but was uninjured. At the point of her falling, the defendant pulled his firearm out. The victim, Mr. Sanders, had threatened to kill anyone or threatened to kill the defendant or the defendant's niece or mother. He pulled out a firearm and shot him multiple times. The victim fell, and the defendant was yelling at him while he stood over his body and then continued to fire, I think, three to four more times into the victim as he laid on the ground. The ballistic evidence was found underneath of his body, pointed into the concrete or the street. I would bring to the court's attention, I know Ms. Bray did talk about his prior felony conviction. He did plead first offender, which ended up being it was an armed robbery, but it was reduced to a misdemeanor. There is a 11 SC 103144 case. It's possession of cocaine with the intent to distribute a firearm in the commission of a felony, in which the defendant did plead guilty to, and he received a 10-year probated sentence. I'm not, based on the time he pled, which would have been in August of 2011, he would be right at the cusp of finishing his probation. I did not see a warrant to revoke his probation based on any of his arrests after that, but that doesn't mean that probation uploaded the warrant. So I'm uncertain to whether he's still currently on probation, but according to his pre-trial report, he is not. So I can follow up for your honor if you'd like me to, as it pertains to that case. Nothing. The risk of intimidating witnesses, we have no phone calls in which the defendant has made to either his niece or his mother that indicate that he is threatening or intimidating either one of them. It is a concern, as the court did bring up to the state as well, that the defendant would be going back into the home with several of the witnesses who would testify at a trial if this case was to go to trial, Your Honor.
Do you agree with Ms. Bray that all the occupants of the Imperial Circle household have already given statements? They weren't ducking the police or refusing to talk. They've given their recounting of what happened when ultimately Mr. Sanders was shot and killed.
They did, Your Honor. I would agree with that. In fact, you brought that up. The statements that his mother and his niece both made to the police on that evening, both of them made it clear that the defendant did not need to do what he did, that the situation wasn't that serious, and that the victim, they didn't even know the victim had a firearm. The victim did have a firearm on his person, which the defendant did take after he killed him by shooting him multiple times, and take both firearms and laid them on the stoop of the house when the police arrived.
Oh.
But they indicated, and I'm sorry for leaving that out, Your Honor, that the victim did have a firearm.
But more importantly, perhaps, neither mom, meaning Mr. Hambrick's mom, or the niece, Mr. Hambrick's niece, said they had seen the gun. The gun, Mr. Sanders' gun, was not involved in whatever he was doing to his girlfriend or his girlfriend's whatever relationship that would be.
That's correct.
Okay.
Verbal exchange.
Okay.
Nothing further from the state, Your Honor.
So your primary concern then, Mr. Abate, is that if Mr. Hambrick were out on bond, there aren't conditions that would prevent something like this from happening again, meaning Mr. Hambrick processes a situation and concludes, I need to eliminate the target, even though the other people in the mix are, this isn't, you're overreacting. What's happening is not okay, but the solution is not to empty your clip into the prone body of the person. Okay, got it.
Thank you.
I'm going to hear from you. Deputy, if you could give to Officer Pretty these two documents. Thanks for your patience. Yes, Ms. Bray.
But Your Honor, I want to point out that prior to this incident, the last trouble we had was back in 2010, and it was indicted in 2011. Like, so obviously he's not someone who just blows everything out of proportion.
Right.
I'm arguing, and I think this is what his trial attorney would be arguing, is that in his situation, what he saw happening, his niece being beaten and dragged downstairs by her hair, and then continued dragging outside.
No, I follow you. And then his mom being knocked to the ground by this guy.
Yes.
What would you do? I'm gonna go out there and stop this guy who's touched my mom.
And just because the mom and the niece are saying, or maybe they said that they didn't see him with a gun, if Mr. Hambrick knew him to be a person in possession of a gun,
Right.
and here you are, you knocked my mother to the ground, you're more physically fit than I am. What do you do?
No, you're making a good trial presentation. So this is one where I need more information goes to the defense. I need you, Ms. Bray, to work with Mr. Hambrick's family to identify what a living arrangement would be where Mr. Hambrick is not residing with folks about whom he feels so passionately, because I think that reduces the risk of something like this happening. It's number one. And then number two, I need to understand a little bit more what he's getting medication for, because that's an area of concern. If the medication isn't right, something like this happens. So I just want to understand that. And you are so new to this that I understand you might need to gather information from your client's mother about what the medication is for, what the diagnoses are. It's not a competency question. It's just let's make sure that things are happening. But then number two, my concern is not Mr. Hambrick's going to influence witnesses. They've said what they said, and frankly, what they said doesn't necessarily help. Hey, overreaction. I don't think that undercuts a defense, but so I'm not worried about that. I just if I'm going to set a bond, it would be for Mr. Hambrick to be in a place where there's less risk of that familial drama that could present another situation like this. But to your point, it's a 34-year-old guy who to date has never done something like this. And I appreciate the charges back in 2010 or 2011 on paper were serious, but we're all familiar with why in the end there'd be a first offender battery plea. It wasn't what it seemed when people were able to dig a little deeper than initially happened. So you gather that information, share it with Ms. Nelson and Mr. Abate, and we can go from there.
So the resident part, we could want a program? 'Cause I don't.
No, I'm not asking you to find it. What I heard you say is you.
Relatives or somebody.
Correct, that you're gonna talk with mom and identify an Atlanta area residence, not a Texas area residence. Who would be there, where is it, that kind of thing. Again, it's not, I don't want Mr. Hambrick away from his mom, that's not the point. I just don't know that he needs to be residing with all those folks while this is working its way through. Plus, it ideally would be a place where we wouldn't have the drama of a Mr. Sanders dragging his girlfriend by her hair out of the house. That excites everyone's passions. It sounds like Mr. Hambrick would admit to it. It excited his passions to such a degree that he went out there to protect his mom and his niece. Did he overdo it? Let the jury decide. This is not a whodunit. This is it's laser focus on, were these actions justified? If they weren't, it's a dead body. If it was heat of passion, voluntary. If they were justified, then it's not a crime. So I'm not asking you to brief the defense. I want you to work with Mr. Hambrick's mother to see if there is a place Mr. Hambrick would be allowed to live for a while in the metro Atlanta area that is not going to be a drama-filled household.
Yes.
That and what's going on with the medication. So you don't have to do too many repeat visits or communications with Mr. Hambrick's family. If you and his mother or whomever it is identify a location, I'd also need an email or a letter from that location owner or occupant saying, I'm okay with this. Because what has not worked well in the past is I'm told, here's a great location, and 2 weeks later we learn, but the person who lives there never said okay. The family thought this is great, but the person who lived there said, not great, I'm not all right with this. And then pretrial services is saying, what do we do? This guy needs to move, he's not welcome here. And the answer is, it was there or Rice Street where you're gonna be living. So we need to make sure not only that mom thinks it's a great idea, but that Uncle Fred or wherever it's gonna be says, I too am okay with this idea. And then we'll communicate more.
All right, and I'll just.
Ms. Nelson and Mr. Abate, get it to both of them.
All right.
Okay? All right.
Hopefully I'll have something by Friday.
We are here whenever.
All right, thank you.
Thank you. And again, I'm sorry that the calendar didn't get to you in its normal channel. I trust you'll fix that.
Yes, I got it.
Good.
You don't know what happened.
All right, Mr. Hambrick, I'm going to get more information from your lawyer and we'll figure out what we're going to do, okay?
Okay.
Thank you. Mr. Abate, you've been here, I've monopolized your day, but we need someone from the DA's office to be here for Mr. Williams's Faretta hearing. Is that you? Or you're gonna get someone else? It'll be you, okay. So let me ask our court reporter if she wants to take a quick break. I know my stomach would like some food, but do you want to do Mr. Williams? It'll be a 15, 20-minute discussion with him and then be done, or do you want to take a break? She'd like to power through.
Yeah, I was ready for that, application.
I can't hear you. That's okay. Just come on up right to the corner there,
Sir.
right there. That's perfect.
I was trying to make my speed way for my dissertation.
Oh, it's maybe with Ms. Niles. I'm gonna be gone for 2 minutes. Let me ask her that and I'll let you know what's going on. Mr. Williams, I'll be back in about 2 minutes, okay?
Well, it was really just one thing to me. Santos isn't a victim. He's not. I was wrong. He's not a victim of this person or whatever his name is. He was killed by Corey McDonald. He was also dead.
That's what I'm saying.
Yeah. I didn't know all that. I'm sorry. Yeah.
Me too. Siri's gonna pop in for just a second for us to get clarification on something for Friday.
Okay. And she was in
Mr. Smith, did you come here earlier? Not Mr. Smith, Mr. Reed.
Yes.
Mr. Reed, did you come here earlier and say you had a job as a cleaner?
Yeah, I haven't got paid, so I just started, like, so that's why I didn't list it.
But you listed it before. You did a different affidavit? You changed your affidavit?
Yeah, I didn't turn it in. I had to change it because I don't have no check stub for the new one. She said if I don't have it, then I can't put it down. So I was like, okay, I got the check stub that I do got.
Well, but if you're making other income, you need to disclose that.
I
So,
haven't made nothing yet. I don't get paid till the 15th of next month from the cleaning job.
okay, but what are you gonna make when you get paid?
I don't know. The hours ain't being calculated and I don't know.
What are they paying you per hour?
They paying me at 12 an hour.
Okay, and then this other,
Extreme staffing.
yeah, what are you doing there?
I'm just doing events, catering events. That's where I'm working at currently. That's why I provided a check stub.
Okay.
Yeah.
And you are trying to legitimate?
That's how I get visitation from my daughter. It was just born in July.
And that's amazing?
Mm-hmm.
Okay, and Amazing lives with Miss Saxon? Okay. So in the future, hopefully you won't have to do this a lot, but in the future, don't put together one affidavit and then go away and come back with a different affidavit, because that raises alarm bells of like, well, what's this guy doing?
Yeah, I was just trying to be honest because I haven't made no income from that other job yet.
Well, it sounds like you've earned it. You haven't been paid yet. If you've been working, then you've earned it, but they don't pay you till the 15th.
Mhm. Yes, sir. So
You give that to Mr. Reed. Good luck, Mr. Reed.
thank you so much.
And then, is it Mr. Satchel Jarrett? How are you doing? All right, thank you for all your paperwork. It is in order. And you are trying to clean up a birth certificate? Is that, you can come on up. Tell me what you're trying to do.
Clean up a lot. My
Okay.
daughter's mom passed, and I legitimated her, and I have the court order, but they never put my name on it. So I checked with them yesterday. She was like, "Oh, somebody else's name on it." I'm like, "How? When I'm legitimated?"
So who has been legitimated?
My daughter was legitimated when she was born.
Right, but if the order would legitimate you as the father, did it legitimate someone else?
No, they just never put it on there.
Okay.
So this is me fixing everything after she passed. I have to find my daughter. I gotta change her
where is
last
she?
name. I don't know.
Okay. How old is she?
7.
Okay. And you don't know with whom she resides?
I know she's with her ex-boyfriend, but he's married, so it's a lot I gotta go through. And at the
You'll
same-
do safely and wisely and legally.
Yeah.
Good. All right.
I mean, this is just my first time being able to get to it because she passed in April, but I'm an actor, so I've been filming out of state for a couple of months. I'm just getting back and I gotta fix all this.
How do you already have a case number? Is that what the legitimation was that was messed up?
I called a judge a couple of months ago, told her my name was never on the, she said, "I'll change it because that's our mistake." She called me back and said, "Oh, I can't do it because I can't pull your birth certificate because your name not on it. You have to find somebody to pull it for you." So I was like, so I have to pay an attorney to fix something that's clearly in writing that you were supposed to. She said, "Well, you were supposed to take this to the birth certificate place." I said, "They never told me that. All she did was give me the paper."
Is your birth certificate messed up or your daughter's?
My daughter.
Okay, so not only is the legitimation had a mistake, the birth certificate has.
No, the legitimation didn't have a mistake. They just never put my name on the birth certificate after the paperwork. So now his,
got it.
her.
Okay, so legitimation went through except for the important final step where they then do a revised birth certificate that says dad is Kashmir Satchel Jarrett.
Yep, so I have to correct that. I got to correct her last name.
It's what we do for the ones we love.
Mhm.
I've signed this. Good luck with everything.
Thank you.
All right?
Yes, you did. Thanks.
All right. Let's turn to Mr. Williams's case, please, a little belatedly. Long morning. You ready, Ms. Rivers?
Yes.
This is 19 SC 16, that's missing the number. 16784. Do you have the? That's not enough numbers. Anyone have the full case number for Mr.?
It's 19 SC 167684.
There was that 6 missing. Okay, there he is. So there are 2 defendants in this case. We've got Mr. Williams today. And Mr. Williams, most of what we do today is going to be a conversation between the 2 of us. You are welcome to stay seated there, but I'm going to have you move closer to the microphone. And we need to make sure that microphone little green light is on. And Ms. We'll get the deputy to do that. It's got to tap the little circle in there. Excellent. Mr. Williams, you are charged with murder in this case. We've met a couple times, but it's been virtual. I think this may be the first time we're face to face. I know I've seen you on a Zoom camera before. But my understanding is that you are interested in representing yourself. Is that correct?
Yes, sir.
Okay, I'm going to ask you if you're comfortable with it, take your mask off, because I need to make sure that, or pull it down, that Ms. Rivers can hear your answers, because we have to have a kind of long conversation about this plan of yours. You were represented for a while by Mr. Franklin, is that right?
Yeah, yes.
Okay. Mr. Franklin was transferred to another courtroom, and his trial partner, or partner in this courtroom, Ms. Patel, became the senior public defender in the courtroom and inherited some of his cases, including this one. You've met Ms. Patel?
No.
Well, maybe you've talked on the phone at least.
What's our first name?
Shamel?
Yeah, I talked to her on the phone.
Okay, you've talked to her on the phone. So she is currently what we call your attorney of record. And so really I should be talking with Ms. Patel, but you have made clear to me that you're thinking about representing yourself. Is that what you want to do?
Yeah.
Okay. I'm going to ask you a bunch of questions, and it's going to sound like I'm trying to persuade you not to represent yourself. But I want to say up front, you have an absolute right to represent yourself. And if that's what you want to do in the end, after I've shared with you the consequences of self-representation, if I conclude that you are doing it knowingly, meaning you understand, and voluntarily, no one's forcing you to do it, I will grant your request and you'll be able to represent yourself. But I'm going to share with you things that will be expressing my opinion that it is rarely a good idea to represent yourself, especially when you're looking at charges as serious as murder. But I'm not trying to make you change your mind. I'm just sharing with you the consequences of self-representation. Okay?
Yeah.
All right. How old are you, Mr. Williams?
31.
How far did you go in school?
High school, 9th grade.
9th grade? Where'd you go to high school for 1 year?
I went to Farragut High School.
Farragut?
Yeah, it's in Chicago, Illinois.
Chicago? How long have you lived in Atlanta?
About a year and 3 months.
How long, that was before you got arrested, a year and 3 months, or just period? You've been in jail too long.
No, I lived here the year and 3 months, not including jail time.
Okay. So before you got locked up, you'd been here for about a year and 3 months.
That's correct.
Why did you come to Atlanta?
Because I actually parole here from another state for a change.
Okay. So 9th grade, are you able to read English?
Yeah.
Can you write English?
Yes.
Have you done any other schooling, GED work or anything while you've been in custody?
I did half of the GED. I ain't never get a chance to complete it because I got distracted.
Okay, were you doing that GED work here in Fulton County or in another state?
In another state, but I've been doing it here too though.
Okay. Do you have any difficulty understanding or speaking English?
No.
Have you worked before?
Yeah.
What kind of work?
Landscaping. I worked in warehouse. I did Atlanta Chemical. It's a bunch of different ones.
Okay. What's the last job you had?
The warehouse forklift.
Was that here in Atlanta?
Yes.
Were you driving a forklift or you were around forklifts?
Both.
Did you have a license to drive forklifts?
No.
Okay. Have you ever studied the law before?
Not like went to school for, but yeah, I studied it like far as within myself.
Sure. So you've had informal study. You're reading books, looking at things on the computer, but you've never gone to law school or taken a college course in the law.
No.
Have you ever watched a criminal trial before?
Yeah.
How so?
Kind of like, besides like reading the trial cases, I would say from the probably the first 48 stuff like that, but I'm pretty sure they like.
Could you speak up a little bit?
I said probably like the first 48 stuff, but it was really just the basics. It ain't show the actual detail.
Okay. So you've seen parts of trials on TV.
Yeah,
but you've never sat through in court an entire trial.
no, not a whole entire one.
Have you ever gone to trial before?
Yeah, I went before, yeah, one time. It was a bench trial.
A bench trial? Where was that?
That was in Illinois.
Okay. Did you have a lawyer?
Yes.
So you've sat through a whole bench trial. There was no jury,
Yeah,
but
wasn't no
witnesses
jury.
were called and sworn in, and the lawyers asked questions.
Yeah, just the officer was witness. Yes, that's correct.
Okay. Witnesses can be officers, but it happened to be officers.
Yeah,
How long did that trial last?
probably about an hour, 45 minutes.
It's a quick trial. Okay. What were the charges?
A drug charge.
Have you ever represented yourself in court before, either criminally or civilly?
No,
Have you ever been under the care of a psychiatrist or a psychologist or any other mental health professional?
no,
Are you taking any medication right now
no.
for anything?
Besides pain pills for my
Ooh.
back.
For your back?
Yeah,
Okay. But that's for pain. It's not because you're hearing voices or
No.
you need it for anything like that.
no.
Tell me why you think you will do a better job than a lawyer handling your case.
I don't necessarily think I can do a better job than a regular lawyer, but I feel like I could do a better job than what I've been getting so far.
Okay. So is your concern not having someone else represent you? It's who has been representing you?
Yeah, it's like a conflict between me and just like the public defender office, period. Like from our conversations, from phone calls, or just talking to a public defender, period. Even Ms. Patel, we had a conversation on the phone and it didn't really go well.
Okay. And I don't want you to go into the substance of the conversations, but let's start with Mr. Franklin. So you felt that Mr. Franklin wasn't doing a good job, or he was doing a fine job, but he didn't see the case the way you saw the case?
I mean, that really wasn't no job. Like I really didn't communicate with him the whole year he was on the case.
Okay. So are you concerned that he wasn't paying attention to the case and that's what you're worried about? Or when you did talk, he just didn't seem to know what he was talking about?
Get kind of both. And then I had brought up an issue as far as like with my case that like a motion for the bond hearing because I wasn't indicted within 90 days, but he said he was going to do one thing, but he never did it.
Okay. Now it sounds like you and Ms. Patel have only had one conversation?
Yeah, on the phone.
Okay.
And I wasn't sure who she really was because I thought Mr. Franklin was on my case.
All right. Do you feel like you've given Ms. Patel a chance to show you how seriously she's taking your case and whether you and she might see more eye to eye than you and Mr. Franklin did?
Like far as like actions, no, but like from the conversation, she told me she would do exactly what Mr. Franklin did. And I told her that he didn't do anything, but that's what she was content with doing.
Okay. So do you feel like you're asking to represent yourself more out of, these are my words, not yours, but sort of desperation or last resort? You'd prefer to have a lawyer, but the lawyer you've had so far isn't up to your expectations?
Yeah, that's correct. It's like I just want a fair trial, somebody that's going to represent me and help me with a fair trial. And I don't feel like I'm getting that right now.
Okay. I understand that. And that's my role too, to make sure you get a fair trial. The jury's going to do what the jury does. I don't get in the middle of that, but I do get in the middle of, hey, wait, it's not fair for the state or it's not fair for the defendant. I've got a bunch more questions that I will cover with you, but I'm wondering if it makes sense for you and Ms. Patel to have another conversation so that you can get a better sense. Here's my concern, that you and Ms. Patel have one phone conversation. It starts out with you very understanding, like, I don't know who you are, lady. I'm not sure I want to talk to you about my case because Devin Franklin's my lawyer. And so you're not sure who it is. Takes a while for you to figure out maybe Ms. Patel is okay for me to talk to her. She don't work for the prosecutor's office or anything like that. And then for whatever reason, you came away from that conversation with a sense of it's more of the same. and you don't want more of the same. You're either going to represent yourself or you want there to be a change. And now again, my words, either more energy or sense of commitment, like, hey, my job is to defend you to the best of my ability. Because let me add this, and then I'll hear from you. I know from experience that Ms. Patel is a seasoned attorney and a committed attorney who fights pretty darn hard for all her clients. Don't matter what the charges are. Yours are serious. You could have a jaywalking and she would fight hard for that. It's what she does, and she does it well. And so I want to make sure that you and she have had an opportunity to see if you can get more comfortable with the nature of her representation. And I'm not asking, hey, so let's delay your trial. You are on the trial calendar, our next trial calendar for November 4th. It actually covers 3 different days when we'll pick a jury. So we don't actually start anyone's trial on November 4th. But either you got to get up to speed and be ready to represent yourself doing something you've never done before. And I'm happy to walk through all the disadvantages of that. Or you and Ms. Patel could have an additional conversation to see if you come away from that more comfortable that having her as your lawyer is better than having you as your representative. What are your thoughts about that?
I mean, she asked me what did I want from her, and I just wanted somebody that's gonna help me with a fair trial and who's gonna represent me. And it wasn't a response. So it wasn't like, okay, I can do that. So it's like, okay, I don't want that then.
Okay. Well, again, I don't want to get us too deep into the confidential communications you had with her. What I'm going to do then is I'll go through some more of this, the conversation that you and I need to have that heads you in the direction of representing yourself. It may be at the end that you say, but I'm going to try one more time to talk with Ms. Patel. And if that doesn't work out, we don't have to repeat this conversation. I can say, all right, if it didn't work out, you can represent yourself.
So basically it's like either me or her, or that's it. That's my only 2 options.
Not necessarily. I could also hear from Ms. Patel, and it may be that we ask folks who are here from the state to step out of the courtroom at the end of the conversation you or I are going to have, so that you and Ms. Patel can speak more freely about maybe what some of the disagreements are, and the prosecutor is not able to hear that. For me to hear your private conversations, it's less of an issue than for the state to hear it, because you can't unring the bell. If the prosecutor hears you say, well, but my key defense is X, he's a smart guy, he's going to write it down and say, hey, this is what the defense is going to be. Let's get ready to deal with that. You might tell me what the defense is, and I'll say, okay, that's what the defense is. I don't tell anyone. And so, because the answer to your question is there may be a third option, which would be if Ms. Patel concludes that there is some conflict between you, and it would effectively be her office now, because Mr. Franklin didn't work out and then Ms. Patel didn't work out. We could get a lawyer from outside the public defender's office appointed to represent you. And then you'd be starting all over that relationship. And I'd be fine letting you do that. The risk we run is you may have standards that are here. I don't know. And if that lawyer underwhelms you, then we would reach the point of, well, you know what? It wasn't Franklin. It wasn't Patel. It's not Jones, whoever it would be. Now you are on your own, Mr. Williams. So there is figuring out, is Ms. Patel the right one for me, or do I see who gets appointed? And I hope that that's a better situation, because if you conclude it's not a better situation, I would have already concluded that the public defender's office needs to come off. They don't come back on, and then you'd be flying solo. But why don't we talk more about representing yourself, and then you can make a more informed decision about, all right, Judge, I want to keep that in my back pocket, self-representation, but I will talk with Ms. Patel a little bit more. All right. Major, are you good, or do you need me? Welcome anytime. All right. Mr. Williams, have you read the indictment so that you know what the charges are against you.
Yeah.
Okay. Tell me what you think you are charged with. You don't need to list every charge. It's a bunch of charges, but in essence, what are you charged with in this case?
I would say the major crime would be murder and armed robbery.
Say that one more time.
I would say the major charges is murder and armed robbery.
I would say those are the major charges as well. Do you know the name of the person you are alleged to have killed?
No.
Okay. Someone named Frank Fluitt, Fluitt. So murder, there's something called felony murder. Do you know what felony murder is?
Yeah, it's like when you it's like you're in the act of another crime before the murder happened, I'm assuming.
You've been doing your homework. So if you are committing an aggravated assault, you're gonna shoot a guy in his foot. I don't mean to kill him, but I do mean to shoot him in the foot. And he dies as a result of that because he bleeds out or gets infected or who knows what. That's felony murder. So you didn't mean to kill him, but you sure meant to do the felony that caused his death. So you're charged with felony murder, armed robbery, aggravated assault, and then some gun charges. Do you know if you're charged with a co-defendant?
Yes.
Okay. Do you know your co-defendant's name?
Anthony Tobit, I believe.
Okay. Do you understand what the possible penalties are if you're found guilty?
Yeah.
What's the maximum penalty for murder and felony murder?
Life, 30.
Say it again.
Life.
Okay, you said a number also.
30.
Okay. You know that you could be sentenced to life without parole if you're found guilty.
Yeah.
Or is that news to you?
Not that familiar with it.
Okay. And life without parole actually means what it says. You would die in prison. You understand that?
Yes.
So the worst possible outcome for you would be you're found guilty at trial and the state recommends life without parole and the judge sentences you to life without parole. You will spend the remainder of your natural life in the Georgia Department of Corrections. You understand that?
Yes.
And some of these other charges could be run consecutive to that, but life without parole is as long as it gets. Do you think you're facing the death penalty?
No, I don't think so.
Correct. Are you a U.S. citizen?
Yeah.
Where were you born?
Chicago, Illinois.
Do you understand that if in the end you decide to represent yourself and you start the trial representing yourself, it might be that you're stuck with that. You get two witnesses in and say, Judge, I'm in over my head. This is not what I want. I don't declare a mistrial and say, well, let's do this again with a lawyer representing you. If you're in and we start, you may remain in the driver's seat. You understand that?
Yeah. What about when you like in my notice, in my motion, I also asked for a standby counsel. So would that standby counsel be able to step up?
Yes, that is another way that this might work out, that you represent yourself, but that I ask for standby counsel to be appointed to assist you. But assist is not always whispering in your ear or, you know what, I'll take the lead detective, but Mr. Williams, you can handle the other witnesses. You are the lawyer representing yourself unless and until you say, no more, I quit, I cannot do this. And then if you did have standby counsel, that person would take over until the trial is over. You don't get to bounce back and forth, shift into, it's my trial, now it's my lawyer's trial. You understand that?
Yes.
You understand that you would be entitled to no special treatment if you represented yourself.
Yeah.
The same rules of evidence that apply to the state would apply to you.
Yes.
Yes. And if you don't know what those rules are, that could make life difficult for you during trial. You understand that?
Yeah.
I won't be making objections for you if the prosecutor is trying to admit something into evidence and maybe there is a valid objection to it. It's not my job, nor would it be appropriate for me to object on your behalf. You understand that?
Yes.
You'd have to know when to object and on what basis to object. You understand?
Yeah.
You understand that if you represent yourself, you may miss possible defenses that are available to you, and you'd be waiving them, giving them up. If you went forward to trial, it would not be a basis for you to say, wait, I need a new trial because I didn't know I could argue self-defense or whatever defenses might be out there.
Yes.
If you choose to represent yourself, the fact that you're not a lawyer doesn't mean that you can avoid having to testify if you want to get something into evidence out of your own mouth. Does that make sense?
Yeah.
I didn't say it very well, but another way to put it is, in a trial, there's an opening statement. That's when both sides can tell the jury what they think the case is going to be about. In a trial, there's closing argument. That's when both sides get to tell the jury, well, here's what the case was about. Here's the evidence you heard. Here's why. State will say, you should convict Mr. Williams. Here's why Ms. Patel would say, you should acquit Mr. Williams. You would be able to give an opening statement and a closing argument, but that's not evidence. It's not your testimony. It's not under oath. You understand that?
Yeah.
Do you understand that even though you've clearly done some reading and research and you know some of the law, you will lose the benefit of the independent perspective of a lawyer if you represent yourself?
Yes.
Do you understand that the state is not required to bring in a rookie lawyer just because you're unrepresented? They could bring in their best and their brightest and their baddest to try to prosecute you. You understand that?
Yeah.
And that the prosecutor will be under no instruction from me or obligation under the law to be more flexible with the law because you're unrepresented. You understand that?
Yes.
Do you understand that if you're found guilty after trial, you would not be able to argue on appeal? Well, of course I got convicted. I represented myself.
Yeah.
That will not be a claim available to you. You understand that?
Yes.
If you do have a lawyer at your trial, you would be able to argue on appeal. A lawyer would be appointed to you to represent you on appeal, would be able to argue, well, that lawyer did a bad job. It's called ineffective assistance of counsel. You understand that?
Yes.
But if you represent yourself, there is no such thing as ineffective assistance of self. Understood?
Yeah.
Do you understand that if you represent yourself, I'm not going to give you extra time to get ready? I mentioned this is on a trial calendar where we'll be trying to get a jury in November and December. You've had whatever discovery you've had, you need to be ready to go. You understand that?
Technically, don't have a discovery.
Well, that would be a reason to give you more time then, because I'll need to make sure if you choose to represent yourself that you get everything you can have in the jail, but this leads to the next thing. You understand you'll be limited if you represent yourself in your ability to research the law.
Yes.
You maybe get on a computer sometimes and you may have some books at the jail. That's it.
Yes.
You will be limited in your ability to do outside investigation. You don't have an investigator who could go to the scene of the crime to take pictures of the crime scene. You understand that?
Yes. Wouldn't I, I don't know if this through emotion or not, but wouldn't I be able to, through state funds, hire a private investigator?
We'd have to talk about that, but you'd have to figure out what to file and how to ask for that. That's not something we'd work through today, but you do understand that Ms. Patel's got an investigator working with her to do those kinds of things. Yes?
Yeah.
Okay. Mr. Williams, do you understand that you have a right to an attorney, so that if you cannot afford one, which sounds like is your situation, one will be appointed to represent you unless you say, it's not working out, me having a lawyer, I want to represent myself. Do you understand you've got that right?
Yes.
Do you understand that that lawyer would select the jury to try the case and would try to keep off the jury those who might be bad jurors for your case.
Yes.
Understand that the lawyer would likely make an opening statement, laying out the reasons why the jury ought to find you not guilty in your case.
Yes.
Understand that this lawyer would be in a position to subpoena witnesses who could provide favorable testimony for you or problematic testimony for the state.
Yes.
And that this lawyer would be in a position to question any witness who is testifying in the case for or against you.
Yes.
That this lawyer would be in a position to object to the prosecutor's questions and evidence.
Yes.
This lawyer would be able to make motions on your behalf, a motion for a mistrial or a motion to exclude something.
Yes.
And this lawyer would be then in a position to present a closing argument, to argue from the evidence that's been presented why it is the jury should find you not guilty.
Yes.
And this lawyer would help me figure out what law I should be instructing the jury on. You understand that the lawyer would do that as well, the jury charge part.
Can you say that again?
Sure. If you've got a lawyer, another thing that lawyer will do on your behalf is tell me what she thinks the law is that I should be telling the jury. At the very end of the trial, and I promise you, you never see this on TV, the judge tells the jury, hey, here's the law you have to apply. These are the elements of murder. And if the state hasn't proven each one of those elements, you have to acquit Mr. Williams. And I get input from the lawyers on both sides as to what the law is that I should tell the jury. Just as an example, if your defense was self-defense, your lawyer would say, here's the language you ought to talk to the jury about in talking about self-defense. If you represent yourself, say, my defense is self-defense, but you don't ask me for a jury charge on self-defense, I might not know to give one. And then the jury wouldn't hear any law on self-defense. But your lawyer would ask for that. Your lawyer would know to do that. And that's a role your lawyer plays. You understand that?
Yeah, so that would be jury charge, right?
Jury charge, exactly. And ultimately, if you were found guilty, that lawyer would argue for leniency at sentencing. You understand that?
Yeah.
Of course, if you don't have a lawyer, all those things I've just described that a lawyer who is trained to do won't be doing any of that for you. You'd need to figure out how to do it by yourself. You understand?
Yeah.
Okay. Mr. Williams, has anyone threatened you in any way to get you to waive your right to have a lawyer represent you in your murder trial?
No.
Has anyone promised you anything in exchange for you waiving your right to have a lawyer represent you in your murder trial?
No.
Understanding the pitfalls and risks and disadvantages of self-representation, do you want to waive your right to have a lawyer represent you? Or do you want to pause and we can wrap up these proceedings at another time and spend a little more time with Ms. Patel figuring out if that is a better course for you?
We could pause for right now.
Okay. We will not need to have this conversation again. It's been taken down. I find that you are intelligent, that your command of English is more than sufficient, and that you fully understand the risks and disadvantages and pitfalls of representing yourself, and that you were poised to exercise that right to represent yourself. But you're asking that I hold off on excusing Ms. Patel from representing you so that you and she can talk more about what her representation might look like, so that you could share with her some of the areas you'd like her to explore, so that you could get comfortable that she's actually making some traction there. And you might conclude, well, better her than me representing Ramel Williams at trial. So you're not giving up your right to represent yourself. We're just going to freeze it right at the end there. And you and Ms. Patel can talk a little bit more. It may be that you do some of that talking now, but it may be that she wants to get you some discovery so you guys can talk about, well, hey, how are we going to work through this? This witness says he saw you doing that. I don't know anything about your case, but she does, and you need to learn more about it. And if at the end of that, you decide, I'd like to stick with Ms. Patel, that's what we'll do. If at the end of that, you think that you and Ms. Patel and I, without the state here, should talk about you know what, I do want a lawyer, but I just got this conflict, this disagreement with the public defender, we could have that conversation. So I could decide, you know what, Mr. Williams, you're gonna have that conflict with every lawyer because you want them to invent something that doesn't exist. I'm making this up, like an alibi. Hey, I was in Chicago when that happened. But if there's a photograph of you at Stone Mountain when it happened, then you weren't in Chicago and your lawyer can't invent something. And so I may tell you, you got a great lawyer. Is this lawyer or no lawyer? But it could be that there's some reason why we go with that other option you asked about, which is we'll get a different lawyer from outside the public defender's office appointed to represent you. And that may address the issue that's arisen. That's not typically how things play out unless it's an actual personal disagreement. Like I just don't get along with this person and the lawyer agrees we don't get along. You need to be able to get along with your lawyer. I don't think that's going to be the issue you have with Ms. Patel, but you may continue to have the concern you've described. And I'll respect that, you know what, I don't have an issue with Ms. Patel as a person, but I don't have confidence that she's working hard in my defense. That would then be a reason probably to say, then you'll probably work hardest in your defense. And so we'll renew this conversation. Does that make sense?
Yeah.
Do you have questions for me about what we've talked about?
No, I got something pertaining to something different.
About your case
Yes,
that you want to ask me about?
yes,
Do you want to ask me about it with the prosecutor here?
yeah.
Okay.
I filed a habeas corpus in office and it was supposed to be ordered to be transferred to you.
It is, and I have it. And thank you for bringing that up because I meant to talk about the habeas as well. So we'll get to that, but I just want to get closure on the self-representation. As I'm understanding it, Mr. Williams, you're going to take a step back, spend a little more time with Ms. Patel, and you and she can agree on what that setting is. Does she come out to the jail? Maybe a little bit will happen right now. It may even be because you're the last thing we've got today that we get everyone else out of the courtroom. I get out of the courtroom and you guys talk right here. That could be part of it. But at the end of that conversation or conversations, you'll be free to say through Ms. Patel, I tried, it's not working. And then we'll get you back here and we'll figure out what the alternative is going to be. But it also could be that Ms. Patel reports, it's clicked, we're working, we've got a lot of work to do, but we're moving forward. Does that work?
Yeah.
All right. Remind me what the issue was with the habeas, because it has been transferred to me, so I've got it. What was the basis for the habeas? And you don't get a lawyer for the habeas, so this is you, me, and Mr. Abate.
Yeah, it was for the bond under set. It was for the bond and for just the bond.
Okay. Let me see if I can get someone to send me the habeas number. How we doing, Chief? I had major English here too. Have I done something bad? My mask is off only because we're having a dialogue. That's it. I'm nervous that next the sheriff's going to come in here. Holt's doing great. Although I miss Gordon. You need to send him back from 7 Echo. We're about to get the case number and I'll pull it up. Did you guys resolve your chairs in the back hallway issue? Glad that wasn't me. Ms. Patel, are you able to stay a little bit to chat briefly with Mr. Williams, or is that works for your schedule? Okay. All right, 1096. Here it is. All right, so Mr. Abate, Mr. Williams filed a habeas petition in late August. It is case HC 01096. And in it, he contends that his detention without bail is illegal, arrested in Chicago. It's a challenge to a cell phone pinging based on a search warrant that he says had a bad affidavit. So, Mr. Williams, what I think we'll do, now you brought this up, is that I will have Mr. Abate figure out who from his office will be handling the habeas piece, and they need to file a response. They need a chance to process this, but they need to file a response. And then if I feel like we need to have a hearing, we'll get you back here for this. If you and Ms. Patel are still working together, she may join you for that. But again, a habeas is actually a civil matter, and you don't have a right to an attorney. That doesn't mean someone wouldn't agree to sit with you and help you argue it or tell you why you can argue it, but maybe it's not going to work out. But right now, it's your case, the habeas piece. The state needs to respond, and then I'll have the input from both sides and can figure out what I'm going to do with it. Okay.
Okay.
So, Mr. Abate, the case again is HC 01096, and you can send an email to Ms. Nelson that we just like to have a hearing and we don't want to file anything. It may be that a written filing is all you need to do. I'm guessing you'll kick it to your appellate crew, but I don't know how your office handles habeases. We don't get a lot of them. Like everything else. But Mr. Williams attaches to the habeas all the things he's talking about. So it's fairly self-contained. But we'll get something from you and then make sure you get it. You can't really do e-filing. I guess you have to mail things in, Mr. Williams.
Yes.
Okay, so if you and Ms. Patel are still working together, we can get it to her. She can get it to you, but at a minimum, we'll get it mailed to you out at the jail. Okay.
Okay.
Did you have anything else?
No.
All right. So I'm going to defer ruling on your motion for self-representation. See how things go with you and Ms. Patel. I'm not deferring the habeas. I'm directing the state to take a look and let me know, here's a written response or we want a hearing.
Am I also waiting on the sheriff on that too?
Well, the state will be figuring out, do they get the county attorney to respond on behalf of the sheriff, or does the DA's office handle it? You named the sheriff correctly because the person who is purportedly illegally detaining you is Sheriff Labatt, but usually the prosecutor's office gets in the mix depending on what the claim is. And your claim is there was a bad search warrant. And so Mr. Abate and his team may reach out to the county attorney because that's who would represent the sheriff. But of course, the sheriff had nothing to do with the search warrant. He is holding you because you've got no bond and he needs to do that.
Was that's why the first subject was about the bond.
Okay, well, and you've named the right respondent, the warden. That's who gets named in habeas, is the warden. And really, there's not a warden in your context, but it's the sheriff. That's the right person. So, but it probably will be the district attorney's office that assumes responsibility for arguing against your requested relief.
I actually wrote you on the first subject
About,
about the bond, the 17,750
okay,
Georgia code.
is that something that you sent in your criminal case or you sent it through your habeas?
Criminal case before I filed Hague, went to why I filed Hague.
Okay, is same argument?
Yeah.
Okay, well, we'll work through it on the habeas side, but you're going to want to talk to Ms. Patel about that, because if it's sort of percolating on the criminal side, that's something for the two of you to talk about. And please don't get discouraged if Ms. Patel's response is, we're not going to get traction with that. It may be that she says it's not a real compelling argument. That doesn't mean she's not interested in helping you work through this. I've skimmed it and I don't know that you're going to get a lot of traction with it. It doesn't mean you shouldn't have argued it, but I certainly need to hear from the state on that. And whether we hear it as the habeas or part of your request for bond on the criminal side, I'll make sure we address the issue. Okay?
But okay, if the Hague says denied, right? I could also go to the Supreme Court after that if appealing in the Supreme Court, right?
I believe you have certain appellate rights if I deny your habeas, whether it's straight to the Supreme Court or if it would be the Court of Appeals. I don't know. That's where a lawyer could help you. But again, with habeas, any help you'd get from Ms. Patel or anyone else is, I'm happy to help you out, but not their direct area. Okay?
Okay, that's all.
All right. Ms. Patel, anything you want to add at this point? Mr. Abate? All right. Well, Mr. Williams, I will hear from Ms. Patel soon about how things are going and either get you back here to say, all right, here's what we'll do, or great, it's good that you guys are going to partner on this. Much better for you, Mr. Williams, if that's the outcome. And your case will be on that November 4 call of the calendar. So unless you and Ms. Patel say, take it off because there's some work to be done, you'll be brought back over here on November 4 for the call of the calendar. That's not jury selection day. That's just when we figure out, all right, I got 30 cases on this calendar and 3 trial dates. Where am I going to put these groups of 10 to figure out who's getting a jury?
Yeah, I had a few of them already.
Pardon me?
I said, yeah, I had a few of them already.
Few of what already?
Trial dates.
Oh, okay. During COVID, we didn't do a whole lot of that, but maybe you did. But this one is just my cases. It's not a bunch of other judges' cases as well. All right. Thank you, everyone. Say that one more time. Okay. Okay, great. We'll do that in just a second. You may. Thank you for all your help today. You've got a few homework projects. Oh, and the Patels are here. No, not a problem. It turns out we were just gearing up. Ma'am, I'll be with you in just a second. I've got these 2 lawyers here and then you and I can talk, okay?
Right, that's what I was, we just want a clarification about the right. Mr. Wheeler? Right.
Yeah, so that was put on, Ms. Nelson is here as well. She saw what was going on and thought, oh my gosh, let's get a hearing. Mr. Wheeler is not here. And so there's really nothing we can do unless you are for some reason interested in doing something without having him here. I don't know if you've even been in contact with him.
I haven't.
Okay.
And so I think we'll meet him here. The state indicated they're trying to revoke the ballot. So I feel that it would be a full hearing if and when we get to that point.
Okay, so we should take it off because assuming you want him here, which is a perfectly reasonable request, there's been no effort to get him here. Ms. Nelson just wanted to jump on it, given the severity of the allegation. Let's not let anything slide through. My understanding is he is held firmly in Alabama and isn't going anywhere, but you're gonna want to monitor, we're not monitoring custodial status in Alabama.
Okay.
But I think there is now a hold on him. That's all I want to make sure is that if there were gonna be efforts to revoke probation, that there is a hold on him and Alabama acknowledges it. And the off chance he were to get a bond in Alabama,
Did you do that? No, I didn't, so.
We don't. You guys.
Okay.
They're done.
yeah, so if you would just circle back on that, because I signed the warrant, I want the warrant to do what it's supposed to do, which is to ensure that we would get Mr. Wheeler here if he made bond in Alabama. I'm not trying to disrupt the Alabama proceedings, and frankly, they're far more serious than what we've got. But if something changes in Alabama, Mr. Wheeler would need to come here next.
Yeah, because I think that's from what I read.
I'll ask them, and I'll give them a call.
Yeah, and cross state lines, it's even more complicated, so,
Yeah.
but if you check up on that, we'll take it off the calendar for Friday. You don't need to be here.
Okay, I'm gonna go check on
Thank you
that.
for checking.
Yeah, thank you guys.
Ma'am, if you come up to the podium, just so I'll be able to hear you, and I'm gonna stand if that's okay, I've been sitting all day.
How are you?
So tell me, you can hold on to it first, tell me your name,
Elena Chase.
okay? And tell me how I can help you.
I just came by to get this document signed. It's called the Academic Comment Market. It's for school.
Are you the young lady who's in school in Kentucky?
Yes, sir.
Okay, so I'm a big fan of the academic common market. One of the things that any judge, not just me, any judge would have to see is proof of residency in whatever county you're trying to get the form signed. So your folks or a parent lives in Fulton County?
Yes, sir.
So what my team told me was that you have an old driver's license that's expired and it doesn't have your current address on it. Is that right?
Yes, sir.
So that's the dilemma, is that I need some proof that you live in Fulton County. If you live in Douglas County, great, you can go to Douglas County, but I need something that shows not that your folks live there, but that you live there. And the way we typically do it is to get an ID or a driver's license. And it usually happens, you're further along in the process, you're already in the school, congratulations. It's usually someone's a senior in high school and the person comes and they've got their little state ID or their driver's license. And I see it says 123 Walnut Street, and that's what's on the application, and it all matches up. And I sign it and you're good to go. But you've got this funny situation, not your fault, but it sounds like your driver's license doesn't have your home address on it. Is that right?
It doesn't. No.
Okay. Is there any kind of document that you would have that has your name on it and your home address?
No,
What
sir.
does the school have you registered as?
Um,
What address?
This address I have on the paper in Fulton County.
So the address on the paper is not what you've got on the license.
Correct.
Okay. Is there a way, and by school, I mean, you're going to school in Kentucky?
Yes.
Yeah.
I'm already there.
You're already there, right? That's why I said you're a little ways ahead. And what's the major you're trying to do?
Merchandising and apparel textile.
Fantastic. I did not know there was such a program. There's certainly not one in Georgia, so you're in the right place. If there's a way that you could get the school to send you something, it could even be an email from the school saying, what was your last name again?
Chase.
Ms. Chavis is a student at our school, and we have in our records that her home address is whatever it is. That would be enough for me because that's official. Really, what I'm worried about is the school being okay with this.
Okay.
And that's why where that requirement comes from. So that no one's playing the game of, I actually live in California, but here's a Georgia address because my uncle lives in Georgia, but you've got a California driver's license, that kind of thing. I know your driver's license was Georgia and it was where you used to live. You just don't live there anymore. So maybe you could reach out to the registrar's office or someone at the school, not your roommate, but an official from the school could send you an email, or me, even better, saying, yep, she's a student here And by the way, her address that we have on file, like where we send correspondence, where those bills get paid, it's whatever that is. And if that matches up and that's not the thing on your driver's license, I'm happy to sign it. I just don't want you or your folks to get in trouble because the common market, people sometimes try to play games with it because it's a big, big savings.
Yeah,
And that's why they set something like that up.
I understand.
Do you want to try to do that?
Yes, may I get your email address, please?
Sure. What I'm going to do is give you, let me see if Ms. Nelson has a card here. Does that have her email on it? Fantastic. If you get an email sent to that address, then they'll get it to me. And if you can do it here, I don't mean for you to have to go back home and then come back here. So I don't know if you've got a phone with you or something where you could try to reach out to the school to get it sent. I'm here all week long doing this presiding stuff. So if it's easier for you to go home and try to work on that and then come back down here, you could come by anytime this week. But you're also welcome just to sit in the courtroom and see if you can connect with the school.
Okay, how long are you here?
5 o'clock.
Okay, all right.
So you got 3 hours and 10 minutes. And then 9 to 5 tomorrow.
Okay, I'll try to get it done within the next hour.
Okay, whatever works for you. But you just bring that same paperwork back and then an email to the email address on that card from some official at school saying, yep, this is our student. And our records show that the official address, home address for Ms. Chavez is this place.
Okay,
All right?
thank you.
Any questions?
No, thank you.
All right, good luck.
All right, thank you.
You bet.
Thank you, Judge.
You bet.
I think they went down. Oh, did you ask them to keep us back?
Oh, I hope they kept Mr. Williams up after all that. He's gonna say, Ms. Patel couldn't even connect with me.
You sure? I mean, I want to see if he's there, but if not, I'll go there tomorrow.
That was a quick exit. I am good. How about yourself?
Mr. Williams.
Settling into the new job?
Yeah, they took him down, but I can get him back
They
up.
do, but that's what you like about it.
It's easier here.
Hopping is the right word.
Are you sure?
Always
Okay.
something. Yeah,
That's why I have to walk around, make sure you all all right.
yeah. Hopefully, most of us are doing well. It's getting busier. I know that's tough for your team because I guess just one jury being, Judge Ellaby pick a jury today?
No, they need to be busy.
No, don't worry, that's not an issue. We can keep them busy. We can keep them busy.
See, COVID got them too laid back.
Too laid back.
We're not having that.
No. I think it will just get busier. And soon enough, there'll be 2 juries picked at once. And then that first floor is going to be madhouse. But your team's doing a great job with it.
I'm recruiting. We got 2 coming in tomorrow.
Good.
And we're gonna have a couple more.
Will those be for folks who ultimately will be in the courthouse or? Great,
They already post certified.
fantastic.
From different agencies. And we post certified comes either to the streets or the courts. And
Paul is named the announcer up.
build up our counts around here, because I think we're one of the counties that really moving forward.
1306,
No, in talking
1308,
with
or
colleagues
1392.
elsewhere, they want to learn how we're doing it so they can try to move at that same pace. With these civil
17
trials,
text.
we're able to, because the jurors only come in after they're selected, it's real easy. And, at least it only takes one of your team to do a civil trial, but we're doing lots and lots of those.
Yes, we building up the platoon.
Yeah, excellent. Well, good stuff. It's good seeing you.
Yes, sir. I'm just hanging out, stopping by, checking on the captain.
9-2, you're on tech.